Item 1.
Yes.
That's why I have to take instruction, Lordship.
Sorry.
Item 1, Lordship.
Yes.
I have to take instructions on
Mr. P.K. Malik. P.K. Malik on behalf of petitioner, Mr. S.S. Kanungo, additional government advocate. When counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on
और ठीक है
2811.
obligation.
Yes.
Item 2.
Item 2, my lord, kindly arjun this matter.
Mr. J. Samantray for the petitioner, Mr. S.S. Kanungo, additional government advocate, same as 1. Date kete kohle? 28/11. Or you want further time?
No, my lord.
28/11. Yes.
Obligation.
Item 3.
Item 3, my lord, on behalf of Madam Jenna.
Your name, sir?
BP Chwaching.
Passover.
Passover.
We taken up at 12:30.
Right.
Yes. Call again.
Item 4.
Item for prefer 1 week after, my lord.
Your name, sir?
Divya Jivan Mishra.
Mr. Divya Jivan Mishra on behalf of UR Jenna. Who is having power?
Dharandan Naik.
Sir, he is a senior counsel. You are not to.
You are Jen.
So on behalf of UR Jenna, for the petitioner, Mr. S.S. Kanungo, additional government advocate for state. Same order. Date 29/11.
Item 5.
To be called again. Yes. Next.
6.
Yes. Item 6, let's say pray a week after, Lordship. Today I have sent the
Yes.
letter
You don't have power here.
on behalf of Jagajivan Pradhan, Lordship.
Miss, I'm just forgetting your name. Sorry.
P.S. Mahanti, Lordship.
Miss P.S. Mahanti on behalf of J. Pradhan for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for. List on 6. 24/11.
Okay.
24/11.
Right.
Or even further time.
No, Lordship, 25.
Yes.
Already sent the letter, Lordship.
Yes.
I'm on this.
Item 7.
To be called again. Yes.
8.
To be called again. Yes.
9.
Item 9 on behalf of Mr. M.K. Mahapatra, my lord, prefer adjournment.
Yes. Mr. Sahoo. Girish, you are Mr. Lenka.
Pratap Kumar Behera.
Mr. Pratap Kumar Behra. Sorry, please. Mr. Pratap Kumar Behra on behalf of Mahendra Kumar Mahapatra. For the petitioner, Mr. S.S. Kanungo, additional government advocate for the state. Counsel for the petitioner. Same order. Date
24/11.
24/11.
Item 10.
May I pledge your lordship, my lord. So in a case of misappropriation, the
Yes.
accused opposite party was let off, my lord, for which the state vigilance was preferred this application seeking
Yes.
release. And the report
Not
is
let
there.
off, acquitted.
Yeah. My lord.
Let off. If the investigating agency has let him off, it's another thing. But he has been
By
acquitted.
the London trial courts. Now, what I suggest, my lords, your lord, there is a
Delay.
yeah, my lords. Delay in fact was indicated 258 days, but due to the exempted periods with for that COVID period, my lords, I think the noting has come up to your lordship.
To take steps.
The noting is there to take steps, my lords.
Steps have been taken.
Steps have been taken, my lords. IN number 13 or 21. Then the limitation matter is taken up. Notice to whom, lords.
15/9/2020 is definitely COVID.
Up to February 2022.
But the difficulty is that it starts that
I could have not.
contagion. The date start because it is 3/10/19.
1 minute, my lords.
3/10/19 is not covered.
The date is, my lord. In fact, 15/3/2020 to 20
Okay,
to 2000.
15/3/20, sir.
No, my lord. That is the extended period. Initially started from 15/3/2020.
Right, sir.
15
So prior to 15/3/20, this is not available.
Yes.
So
And
3/10/19 to 15/10/20, you have to.
And it comes up to 28 February 2022, my lords.
Latter part is not a problem. The earlier part,
The earlier,
prior to contagion.
my lords, the Supreme Court decision 2021 says that the period from 15/3/2020.
Sir, 15/3/20, sir, I have sent 4 times. You have said 4 times.
Correct, my lords. And that
No, I may be wrong, but-
initial date is 15 March.
So 3/10 to 15 March, 3/10/19 to 15 March is 6 months. Roughly.
That has to be explained.
Not 10/11. 12, 1, 2, 3. 180 days, roughly. That has to be explained. So I'm issuing notice.
Yes, no, I'll file the requisite notes.
Or shall I list after it, sir? Let them correct themselves because it's a wrong noting by the office. So I'll be issuing notice on the next date.
Your Lordship may issue that will save some time to file the requisite. That is required, but it maybe will be.
No, actually, the problem is that nowadays this has become a problem.
No.
At times they are not simply not giving anything.
Not applying the amendments.
No, may not be, but they are not giving the details. The court is not in a position to know. Here it is, the dates are given.
All right.
Dates are given. That is how I am able to know it.
One proposition, sir, streamline that one.
Yes, sir. Sangram, the Standing Counsel for the State, IA 13 of 2021. The stamp report filed by the stamp report by the reporter indicates that there has been delay of 258 days from 3/10/2019 to the date of till the date of filing, that is 15/9/2020. The Lord Standing Counsel appearing for the state submits that in view of the order passed by the Honorable Supreme Court in re contagion.
In the case of cognizance for extension of limitation.
In re contagion. From 15/3/2020.
March 2020.
From 15/3/2020
till 28/2/2022.
Till 20.2.2022 has to be excluded while calculating the delay in filing the petition. Registry shall verify and do SR again. List for orders on next week. Aji kete hela?
Aji
AK. Mr. Das, let it come on 8th.
Yes, ma'am.
I'm giving them 1 week time.
So, resubmit the reports.
Yes, sir.
11.
Thanks to you, actually, I could point out them, but because that date always they are confused. But one thing I must tell that some of them are very conscious and they are mentioning and giving the order also and calculating.
Exactly.
Pin Karandu. Yes, Mr. Mahanti.
Yes, my lord. I have filed an appeal against the respondent to your lordship, Sri Dharanidhar Trethi, against the Laden Lower Court below of order judgment passed by the JMFC Baripada, my lord.
Yes.
Factual metrics of this case, my lord, that without giving and without analyzing the.
Sir, you must be hearing my deliberations with the bar. Bar definitely educates me. This kind of approach, we must understand that that doesn't cut any ice without analyzing any evidence. So please be specific in your submission.
Yes, my lord. In the evidence of the lower court below, which has been.
Where you have taken those grounds, straight away come to the grounds where you have stated what has not been considered.
Yes, sir. My lord.
I have been indeed lucky, actually. I have been indeed lucky to, file appeal in so many cases.
Yes, my lord.
So though I mean the standards are somehow have been diluted, but still then with the length of case you have to make out. And it's a judicial order having jurisdiction. That the scope of revision, is very less. It's not exactly appeal.
Yes, my lord. In this context, my lord,
So which part of the finding of the court, which part of the discussion of the evidence?
Yes, my lord.
Is your best case? Is your best case to seek a revision? Straight away come there.
Yes, my lord. In this context, the respondent has admitted that I have not filed.
Sir, don't give a speech, sir. Don't give a speech. It's good that we are in YouTube, but nobody is expecting a speech from you. Sir, this is a serious court.
The respondent has admitted that I have not given the.
Straight away come to that, sir. Straight away come to the discussion part of the.
lower court below has not.
Sir, don't give again. You are giving a speech. You come to the specific paragraph, page, what you have
Yes.
read yesterday evening.
In the last para of the judgment, my lord, considering the fact and
That is the conclusion part, sir. I am not asking. Conclusion, definitely you are aggrieved and you have challenged. I am not saying that the conclusion is in your favor.
Yes, my lord.
Conclusion, you are dissatisfied with the conclusion. You straight away come to that. Which issue has been wrongly decided?
Yes, my lord.
Or you take time and prepare.
Yes,
This is you see, this platform of virtual court at Mayurbhanj is an opportunity for you.
yes, my lord.
And not to make speech, please. Not to go. Krishna Chandra Mahanti being present. Krishna Chandra Mahanti being present at the virtual court. Being present at the virtual court, Mayurbhanj at Baripada of Odisha High Court. Addresses arguments. The learned counsel seeks further time to advance arguments. As prayed for, list on.
चारी ए के बाद
एक के बार Mr. Mahanti.
Yes, my lord.
1 December, 1st of December.
Yes, my lord. I agree.
Yes.
item 12
Please, my lord.
Yes.
My lord, in this writ petition, my lord, the
Yes,
petition.
please. Please carry on, sir.
My- In this petition, my lord,
Quashing of invoice. What kind of invoice?
Demand has been raised, my lord.
Money.
Money under the linkage star by Mahanadi Coalfield, my lord, which is
So
subsidy.
can declaratory relief be granted in
It
exercise
is not a-
26?
My lord, in a contractual matter, there are decisions from AVL Corporation, my lord, knows ever.
So
When there is
only a single decision
My lord,
where a money demand has been quashed by a court.
my lord,
Please show that.
my lord.
Supreme Court.
One decision I am carrying, but there are several decisions.
No. See, I am only asking a single decision. You have to show me where a money demand has been quashed
My lord,
by declaring it to be illegal or
my lord.
not payable. And please be specific in the paragraph and the
Right,
line.
right, my lord.
Where it
I am
is.
pointing it out. It is 2015 9 Supreme Court cases, page 6-433. I have given a copy, my lord.
Yes.
State of Kerala and others versus M.K. Josh.
Sir, this is well discussed and well known judgment.
Yes. That's what I am saying.
Sir, have you heard the question?
I have heard.
Kindly do me a favor in repeating the question. What I have asked
Means
you.
whether a declaratory decree can be passed in was a monetary demand. Money.
Invoice. Thank you. Yes, that's the point.
That's the point.
Because
Madam,
scope of interference.
Right, my lord. Maintaining validity of the writ petition, your lordship are asking.
So there is a latest decision.
Right, my lord.
Mr. Dey, there is a latest decision. That is latest
There is
decision.
I am not.
Very recent. That whirlpool principle is to apply. Alternative statutory remedy is not a bar. That is well taken. But
Here-
quashing of invoice, the prayer, that I want to say.
Right, my lord.
Yes.
Right, my lord. My lord, actually, if there is an arbitrariness, Article 14 is violated, my lord. They have discussed in that MJS, my lord, however.
State away where it has been quashed in M.K. Jose, where the money demand has been quashed.
My lord, the principle has been laid down. My lord, paragraph 17.
Sir, kindly,
I'm reading it.
sir, we will go to the principle.
Yes.
Please show me that.
That's what I am reading, my lord. What
Please.
principle has been enumerated.
Sir, please, straight away come to that line where it has been
My
quashed.
paragraph 17, page 443 of the decision. Paragraph 17.
Yes.
while discussing the ABL international judgments ratio, my lords, next page, para 27, next page, my lords, 434.
Yes.
From the above discussion of ours, the following legal
Sir,
principle.
434 or 443?
444.
Yes. So it is 443, not 434.
No, my lord.
Yes, yes.
I'm sorry.
Kindly carry on. Kindly carry on.
444, my lord, come.
So in entire page 444, that nowhere they have quashed any money
No,
demand.
it is not a question of quashing, my lord. What?
Sir, it is a question of quashing. Please read the prayer.
My lord, my submission is, my lord, in the context I have to submit a little factual submission, my lord. My lord, this demand, a demand was raised pertaining to the year 2012 and 2013 on 4/3/2023. That there is a supplementary bill is raised.
Sir, please come with a decision where a money demand has been quashed. Supreme Court. You take as much time. I am not dismissing your matter. Neither I am admitting. If you want that, I will respond to your. Then I have to dictate that order. That nowhere it has been quashed in M.K. Jose. So come with a single decision. Single decision interference of. In fact, M.K. Jose is not better than at least Whirlpool. The principles are very clear. This court can interfere. So a demand has been quashed. Kindly look at your prayer at paragraph.
Yes.
Kindly read that. Can read that slowly. 1 and 3, please.
What is to show as to why the invoices number such and such
First one.
First one.
Invoices, yes. So and so.
So
3 to 20.
shall not be quashed. The invoice means a demand.
Please kindly then read.
And upon failing to show cause or upon showing into rule be made absolute.
Sir, Roman 3, sir.
Roman 3, right. To direct the opposite parties to refund the petitioner by reversing the debited amount of this much to the credit of the petitioner.
Read further. That is important actually.
Petitioner's deposited account lying with the opposite parties and indicated in the balance sheet of annexure 8.
Yes. So this has been allowed. You see there. So please, you find out a decision and make your submissions.
All right.
Mr. Deepak Kumar Dev for the petitioner versus for the opposite party blank. The learned counsel for the petitioner, after advancing some arguments, seeks further time to make submissions. When do you want, sir?
2 weeks after.
As prayed for, list on
21
will be fine. Yes.
Item 30.
So that third paragraph, Roman 3, actually makes it abundantly clear that it has to be declaratory.
No, it is a consequence.
It's not consequential. One is to certain extent still difficult.
But if demand is illegal,
the whole problem is that if I take your submission seriously, then I have to respond.
Right, Manas.
So that is how I'm trying to.
No, Manas.
So what is the discussion? I have to tell you clearly. Roman 3 is that the credited amount is to be debited from the account and recredited to your account.
Right. Yes. Because unilaterally.
So I think I have understood it correctly.
Right.
Yes.
Right.
Yes.
But
21st of December. 21st of November.
21st.
Yes.
Item 13.
Call again at 12:30.
14.
Yes.
I'm praying for an adjournment.
Your name, madam?
Ananya Mishra.
Miss Ananya Mishra, on behalf of Suchit Naik.
Suraj Mahanti.
I'm sorry. Suraj Mahanti for the petitioner. Mr. S.S. Kanungo AGA for the state. Learned counsel for the petitioner seeks accommodation due to non-availability of the arguing counsel. List on
कोड़िए
Milord,
20. How much time you want?
Milord, at least 2 weeks, Milord.
December record.
Please.
So today on the fast. 2011 he's saying.
Already.
Yes.
Obliged, Milord.
Yes, please.
15
May I please? I pray, I sought for some documents, man.
Yes, please.
I pray for 1 week.
Yes, Mr. Amitabh Tripathi for the petitioner. Mr. S.S. Kanungo, additional government advocate. The learned counsel for the petitioner seeks further accommodation to obtain instructions in terms of the earlier order dated 4/10/2023. As prayed for, list on
20. We commencing in 20. 2011.
2011. The learned court below shall provide the registrar shall call for a report from the learned court whether the petitioner has surrendered after the period of
Well, I have surrendered. On 23/9/2002.
surrendered on 23/9/2023 as stated by the learned counsel for the petitioner. Yes.
Obliged.
Yes.
16
18/10/2023, he has obtained copies of the depositions of the witnesses. Copy of the said deposition shall be filed in the court today. The scanned copy be updated. Learned, the copies of the copies of the depositions shall also be served on the learned AG to go through the same and during course of the day and go. Was to enable him to obtain instruction.
Next week, Milord.
As prayed for next week, Cordian.
no
9/11.
Yes, yes.
Thursday. Yes.
Obliged.
item 18
18.
item 19 Ashok.
Yes. Call again. Call again at 12:30. Yes.
Item 19
Call again.
20
May I please permitted to withdraw your lordship.
Your name, sir?
DK Dora, your lordship.
You have power here. Apangar power achi.
Amen.
Mr. DK Dora for the petitioner. Bookmark nahi. Again, same problem. Bookmark no rahle खोजी के बाहर करियो नहीं. The impugned order you have challenged here, the rejection order is dated what? What is the date of the rejection order?
My lord, 2/5/2023.
Sorry? Kindly just speak to the microphone. Upon कहला, maybe when you are speaking,
My lord, 2/5/2023.
523 was rejected. Okay. Right. He's a history seeter or what?
My lord,
This particular petitioner is a history seater.
no, my lord.
Then why were withdrawing the petition?
My lord, last occasion, lordship directed to file a criminal antecedent, my lord. But no one coming on behalf of the petitioner to do the swear the affidavit, my lordship.
You see, these kind of persons require your help as a lawyer. If he is unable to furnish bail bond, then he will languish behind bar.
My lord, that's true.
So he is still in custody.
My lord,
Mr. D.K. Dora. For the petitioner, Mr. Devasis Nayak, Additional Government Advocate for the State. When it comes for the petitioner, you are filing a memo.
my lord, I'll file a memo.
The Learned Counsel for the petitioner files a memo stating therein that the petitioner doesn't want to press the petition. Accordingly, the petition is disposed of, granting liberty to the petitioner to renew his prayer subsequently. Yes, the report. Of the learned ADJ Kuchinda, dated 18/10/2023. District Judge Hon'Ble, dated 18/10/2023. Indicate that the petition of the application of the petitioner in BL APL number 14 of 2023, corresponding to GR case number 13 of 2006, was rejected by the learned court of the learned ADJ Kuchinda by order dated 2/5/2023. Yes. Yes, next.
Oh, bless you, lordship. May I please, your lordship?
Yes, please.
Lordship, here the present petitioner is a widow lady and languishing in judicial custody since 27/2/2023. And the charge sheet has been submitted on 23/8/2023. And
She is from which place, sir?
my lord,
West Bengal.
Medinipur, West Bengal.
West Bengal, my lord, sir, called
So this actually, I mean, what you are saying, the concern is right, but this has become the regular practice now.
My lord,
I mean, in almost all the jails where NDPS cases are, there is noticeable transaction in NDPS or cases are reported. Ladies are from other states, they are languishing.
I bowed on last occasion also, your lordship directed for the criminal proclivity of the present petitioner, my lord. And
Yes.
the father of the present petitioner has filed the additional affidavit.
my lord had called for the updated CD and criminal antecedent. There is no criminal antecedent that had been communicated earlier, but the updated CD has not been received.
So what you can do as a lawyer, that you can persuade them to the local surety, the details of the local surety, they can file affidavit. It will go to the learned court in season of the matter. But
Right.
first you have to show this court that bona fidely you are having local sureties who will ensure our appearance before the court. To do that, you have to be more proactive here as a lawyer. Actually, you must understand the limitation of the petition. This territorial jurisdiction has a difficulty.
My lord. My lord, I will file accordingly.
It is like everyone is carrying nowadays less than commercial quantity. More number of women are what you call, they are roped in. They are roped in to become the conduit of the material contraband.
My lord.
Here, what is the quantity?
My lord,
Ganja.
no, my lord, brown sugar, 302 gram.
A significant amount. You are Mr.
Siddhant Kumar Jana.
Mr. Siddharth.
My lord.
Mr. Siddharth Kumar,
Jana.
not Siddhant.
Siddhant Kumar Jana.
Mr. Siddhant Kumar Jana for the petitioner, Mr. Devasis Naik, additional government advocate for the state. Internet counsel for the petitioner submits that in terms of the earlier direction, the father of the petitioner has filed affidavit, which is on record. Copy has been served on the learned AGA. You have received copy?
My lord.
The learned AGA submits that he has not received up-to-date instructions in the matter and may be accommodated. The learned counsel for the petitioner seeks further accommodation to obtain specific instruction regarding local sureties. The learned counsel shall have the learned counsel for the petitioner shall have the liberty to file affidavit if so advised on behalf of the local sureties, along with the details. Yes.
Grateful, your lordship.
Yes.
This is to be listed after.
When do you, how much time is required? Because
My lord, post Diwali.
as paid for list on 15th.
Your lordship.
You do it early so that you serve a copy and they will then have to verify again.
My lord.
Yes.
As soon as possible.
Basically,
I
you
will
should not wait for these things. After this trend has developed, that one of the ways of releasing outside the persons of other states is that you ensure local surety, some cash security, substantial, all those things you have to keep it in your mind and you have to be more proactive.
My lord,
You have to understand the person who is behind bars, she has no one around in the state.
I have already communicated this.
It will be difficult for you to also get the instructions.
My
That is how the time is taken. No, I am not finding any fault. Please don't. That's not the purpose also.
No,
I'm just
lordship,
thinking along the
last
discuss.
occasion also I have communicated the same to lower court counsel,
Yes.
but there is lack of communication between.
There will be, because they are the outside state and you see the age of the father is 73.
73.
Yes.
My lord,
Copy of the affidavit, if any, shall be served on the learned AGA.
no,
Sorry.
as just my lord praying, my lord has posted it to
1511. Kebe koile? 1511.
my lord.
Grateful, your lordship.
Item 22.
Mr. Dwivedi.
Last again, Lordship directed me to file the affidavit regarding the criminal proclivity.
Seek further time.
Your Lordship's permission, can I file it? I have already prepared.
Yes. But I am not permitted to break the glass. That is a difficulty. And as such, it is scarcely available. I am told that it is manufactured in Australia and all those things. In fact, I waited for about 4 months to get a Mr. Siddhant Dwivedi for the petitioner. Mr.
No CA in the record also.
Yes, you serve it. Can I presume that they know everything? You see, at times very innocuous submissions makes no sense. How do I know that they know everything? Who is he to know that?
My record is there, my lord.
Okay, he will submit that. It is not that, they're not against you. Whatever is a fact, he will state that. Mr. Naik, you have received
I
instruction.
received there is no criminal antecedent.
Okay.
The charge sheet was filed on 19/5/23. There are 15 witnesses to be examined. So the status of
What is the quantity, Mr.
80 gram only.
It has to be below definitely
Below.
commercial quantity.
Yes.
That is the now the modus operandi.
Trial has not commenced and
Charge sheet has been final prosecution report has been submitted.
charge sheet submitted on
You
17/7.
serve a copy of that affidavit and the AG.
Yes,
Where is that affidavit?
I have.
Serve it.
I-
Anand copy. What is the age of the petitioner?
It is my lord. 42.
Never. The Lord Counsel for the petitioner submits that in terms of the order dated 6/10/2023, he has received instructions that the petitioner has no past allegations of criminal antecedent against him. The Lord AG, referring to the instructions received from the investigating agency as contained in the case diary, submits that there is no past criminal antecedents against there is no past allegations of criminal activity against the petitioner as per the police records. The Lord Counsel for the petitioner submits that the petitioner shall abide by the terms and conditions that would be imposed for granting bail. The amount of contraband seized from the petitioner is less than commercial quantity. Being a local person having roots in the society, the petitioner shall not avoid the jurisdiction of the court in session of the matter. The learned AG, referring to the materials contained in the case diary as well as the provisions of the section 37 of the NDPS Act, opposes the prayer for bail. Having had learned counsel for the petitioner as well as the learned AG, this court is inclined to grant bail to the petitioner subject to such stringent conditions that would be imposed. Such terms as such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also contain a condition that in case of any deviation from public violation of any of the terms and conditions, in case of violation, the law enforcement agency informant victim shall file petition for cancellation of bail, disposed of accordingly. Say Asik. Yes.
Item 23.
May I please, Your Lordship?
Yes, please.
The case under section 21C and 29 of NDPS Act.
Yes, please.
And the petitioner is in custody.
Affidavit delegi.
Yes, yes.
Have you received the up-to-date instruction regarding
No, my lord.
affidavit copy kebe serve kale?
Copy, sir, before
1310 affidavit he has filed. Just check your brief whether he has served. Or maybe he has filed, it has not come tagged to your brief.
13th, 10th.
Sir, that day you have filed, but when did you serve that copy and why you are not filing the receipt in the registry?
Receipt, sir.
On the receipt you should file in the registry so that the record gets updated. I am trying to search it. He is also trying to search it. Kebe file करछंती? Date tak माने kebe copy serve करछंती?
13th, 10th, 2000.
Same date. The Lord, you obtain instruction.
My lord.
You are Mr.
Swayam Prakash Das.
This is item
23.
23. So Swayam Prakash Das for the petitioner, Mr. Devasis Naik, AGA for the state. Alright, counsel for the petitioner submits that in terms of the earlier order dated 9/10/2023, affidavit on behalf of the petitioner has been filed on 13/10. Copy of the said affidavit has been also served in the office of the Advocate General. The lauded AGA seeks accommodation to obtain instruction. As prayed for. Lister. How much time, Mr. Naik?
My lordship, 10 days.
Lister.
20.
आज कितना गए के?
जी
14. 14, 11, 20, 23.
24.
May I please?
Yes. What is the defect, Mr. Pal?
And for my lord direction, I have filed the affidavit, my lord. Here, the petitioner is in custody since 27 years, my lord.
He started his activity in 2017.
Yes.
6 वर्ष हो गया, there is no change or no improvement. How many times he has been granted bail by the courts?
Yes.
There was a condition that after being released on bail, he shall indulge in similar criminal activity.
No.
Then what is the way out for him? Actually, he's safe. Wherever he is, he's safe.
My lord, my lord, all the antecedents are of the year 2018-19. And in this case,
No.
There is one of 21, 22 also.
22,
18 is there,
Yeah,
17 is there.
yes.
Now Mr. Pal knows that.
Yes, my lord. And my lord, meantime, charge sheet has been submitted, and since last 6
In all cases.
Yes, my lord. In all cases, he is on bail. And in this case, my lord, charge sheet has been submitted. And he is in custody since last 6 months, my lord.
Obviously, sir, he has to be every time if there is a condition imposed by any court, then I will follow that condition. That after being released on bail, he shall have the liberty to indulge in similar kind of criminal activity.
Right. This is, my lord, a little more serious also because he's threatened the girl's family that unless they release her and allow her to marry him, he will kill them. If he's out on bail, that will create a dangerous situation.
My lord, due to love affairs, my lord, there is a love affairs between the...
When did he start this love affair?
Since, my lord, 1 to 2 years, my lord.
After watching some movie or what? When exactly can you? There is a purpose of asking this.
My lord,
I think this is the idea after he become. Post 2017.
Yes.
And his 27 statement, he says that it is one-sided completely. That's why they...
Obviously, sir, he's thinking to be law unto himself.
My lord, any stringent condition may be imposed, my lord. He will...
Sir, stringent conditions granting bail to you earlier, bail to the petitioner 8 times have failed.
This is for the last time, my lord.
How do you know?
He will appear in every week, my lord, to the concerned police station, my lord. Sabu saptahare aଜ୍ଞା ଥାନାରେ appear କରୁ and made signature there, my lord.
Have you read paragraph 2? The allegation FIR has been reproduced. Of course, you must have read.
Yes.
What he's doing? How do you control and contain him? His age is a matter of concern. Actually, he's so young.
Yes.
27 years,
Yes.
and already he's having a past 7 years of activity, 6 years of activity, and where he is heading?
Any stringent condition may be imposed.
Mr. Naik, you obtain instruction how specifically this family of the girl can be protected.
My lord.
Because the narration also, in a way, also shows that the failure of the law enforcement agency, that anyone likes to do whatever he wants. You also think about it.
My lord, my prayer is that, my lord, the petitioner will appear in every week to the concerned police station.
How does it help him?
With,
In between appearance, he will go again with the bike, hold a gun,
in the meantime, he
waylay the girl, threaten the family.
Meantime, he is in custody since last 6 months, my lord. The rigors of law he has been, my lord, dealt with.
Sir, that is not actually applicable here. He remains undeterred for the last 7 years. And if the girl's family, assuming that and whatever he has done, that could not be for the first time. That was for the last time. They would have tolerated for some time. They have mustered courage to report it to the police. Then what is the responsibility? What is the responsibility to the society of this whole process of granting bail 439? Where his gun has been seized.
Yes, my lord.
The only concern is that his age, whether he can be reformed. That is the only concern. Otherwise, he is a menace. And what is the logic of that after the girl's family, they have mustered courage to at least seek recourse to law?
It's been 6 months. If in the meantime the girl has gotten married, that creates another problem.
Actually, he threatened them also.
My lord.
She was got married.
That's another problem.
Only because you are in custody. Otherwise, you have threatened the would-be groom there.
Yes.
And there is no, in fact, what really disturbs is that there is a possibility that he will be more violent after returning back, after being released.
No, my lord.
How do you know? Arjun Kordiyantu, Tekhantu. Think about it. Think something out of box.
My lord,
because here the reasons for not granting bail are so strong.
Yes, my lord. And
yes. Mr. Amlan Saktipal for you have obtained instruction regarding the affidavit.
My lord.
Has he served copy?
I have, but the CD.
Or he has simply copied from your case diary. Usually what they are doing, they are getting the instruction.
The affidavit says,
yes,
he has 6 antecedents, 6. I have my instructions, he has 8.
So you prepare a list and give it to him also.
I have the list.
The best way is that it should be rejected at this stage, so that he remains protected also. Since I'm already adjourned, so I'm thinking aloud. I'm not rejecting it now. Because after I have said I will not reject it. But you must understand where you stand. The petitioner where he stands, the lawyer at least he should understand. The learned counsel for the Mr. Amlan Saktipal for the petitioner, Mr. Devasis Naik, AGA for the state. Learned counsel for the petitioner submits that he has served copy of the affidavit filed on behalf of the petitioner through his father, indicating the past allegations against the petitioner. The learned AGA submits that as per his instructions, though it has been disclosed in the affidavit filed by the petition on behalf of the petitioner, as per his instruction, there are 8 past allegations against the petitioner, though in the affidavit filed on behalf of the petitioner, 6 incidents have been disclosed. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction. The learned AGA shall obtain up-to-date instructions and case diary. Status of trial. Status of trial. Up-to-date instruction and status of trial. Yes. As break for list on?
22
December. When do you want? By Segar.
May I pray, my
Yes.
lord? The status of trial, my lord, may call from the lower court below.
We want the registry to call for.
My lord, my lord.
There's no point in because he has so many cases against him.
In all the cases.
All the cases.
criminal
Since Mr. Paul is thinking of what to do, so I'm just urging the matter.
May I please, your lordship?
Yes.
My lordship, last occasion, my lordship, and that my lordship directed to file an affidavit. That's why I'm filing the affidavit. And last occasion, also due to my lord senior is objected that due to the Dasara completion not religion bill that on the puja holidays time, my lordship.
So you are a celebrity, sir.
No, my lordship.
So you are having 17.
No, my lordship. That's antecedent. The recent occurrence also I'm giving the antecedent. Including the Donga case.
Those are also pending.
Including the Donga case, I am giving the affidavit.
Total 17 cases.
Total
Self-same incident re keita achi total 17 taru 4টা
5টা mailers.
4টা only 4.
But I am filing the 5 numbers of bail in the same incidents. One is pending mailers.
All other persons have been released.
Yes, mailers.
Since how many days he is in custody?
Mailers, I am arrested on the 18/4/2023 mailers.
Yes, Mr. Kotak.
Yes, this is antecedents, sir, since 2014.
Yes.
And there is also he has been implicated in 395.
But in so many cases, he has been granted bail actually.
Okay.
That is the other aspect.
Yes, please. Yes.
This is item 27 to 25. Mr. Rakesh Kumar Das for the petitioner. Mr. Janmeja Katakia for the AGA for the state.
And this is the person for whom the entire incident has happened.
Yes.
The main person who has created
so what I'm thinking, because what is his age?
28 years, my lord.
It is the same thing that for a youngster to stay inside custody militates against the theory of reformation. And like the last case, Mr. Pal was arguing that they are not mending their wage. So at least let us give them a chance.
And only submission.
But Mr. Das,
my lordship,
that condition of cancellation of bail will be there.
My lordship.
And you must make him understand the consequence.
My lordship.
It is harsh.
Even my lordship in one
The learned counsel for the petitioner has served the copy of the affidavit dated 18/10/2023 on the learned AGA. The office note put up by the registry regarding this copy not served shall be treated to be complied with. The learned AGA, referring to the case diary submitted by the investigating agency, submits that the information furnished contained in paragraph 3 of the affidavit is in sync with the information contained in the case diary.
Yes.
The learned counsel for the petitioner submits that though there are several instances of past allegations of criminal activity against the petitioner, but given a chance, he shall mend his wage and would also there will be a possibility of he integrating with the society, leading a normal life. He submitted that petitioner, being a local resident, shall not avoid the jurisdiction of the learned court in season of the matter, and the petitioner shall abide by the conditions, that bail conditions you are furnishing in
Yes, Your Lordship, there is the BLFL 616, that is there.
Flag B.
Tagged.
Flag A.
Lordship,
sorry, calling
6616 by 2023.
That may be imposed for grant of bail. the learned AG, referring to the allegations against the petitioner and the case diary and the past allegations against him, opposes the prayer for bail. It is also submitted that perhaps the petitioner is the person at the at whose instance the entire disturbances happened. It is submitted by the learned counsel for the petitioner that out of the same incidents, 4 FIRs have been filed against the petitioner.
5 FIRs.
Five. Out of the incident, incident that occurred on date kebe?
My lordship,
Incident date.
my lordship,
14/4/2023. 5 incidents, 5 FIRs have been lodged in how many PS cases? Dhanupalli and Sambalpur town,
Dhanupalli and Sambalpur town.
in Dhanupalli PS as well as Sambalpur town PS. Not as well as, and in all the cases, final prosecution report has been filed.
FIR was lodged 15. FIR was lodged.
Forget that. Argue kariye setole. Delay in lodging FIR.
No, my lordship. That is
Kon etre bail le kon relevance hoche. In all the cases, final prosecution report has been.
In all these cases, final charge sheet report is.
Final prosecution report has been filed on
10/9/2023.
Since 10/9/2023. Para. Having heard learned counsel for the petitioner and the learned AGA for the state, this court is inclined to grant bail to the petitioner. Subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also contain a condition that all the petitioner shall not do any act overtly or covertly to incite communal passion, shall not leave the jurisdiction of the learned court in session without intimation to the IO, local police of jurisdiction, which shall also contain a further condition that deviation from any of the terms and conditions imposed for grant of bail, deviation from violation of bail shall result in filing of the application for cancellation of bail by the law enforcement agency complainant victim, disposed of accordingly. Yes.
Item 26.
Understood. 2 more conditions will subject to your lordship's appreciation. Let him appear before the PS in every week.
Whatever stringent condition, if the condition is that he has to sit in the PS, then they have to come here.
Because participate in any rally procession, because he's the person.
No, and basically, since the local conditions, the best court is, I think, the local court.
Yes.
So if you want any hearing, the conditions shall be imposed after hearing the learned counsel for the petitioner. The conditions of the bail shall be imposed by the learned court in session after hearing the learned counsel for the petitioner and the prosecution. Yes, in the matter. Yes, please. Next.
Item 26.
And Mr. Das, in these conditions, if I am given a liberty, I'll say that from morning 6 to evening 6, for at least for the initial 15 days, you will sit in the police station. Because you see, you are wasting by granting bail. He is also wasted. He is not safe outside. You never know what he will do, wherever he will go.
Even if my lordship, that I am not leave my house after getting the bail.
No, the question is that, I mean, has he been deterred? The whole purpose of granting him bail since for the last 7 years, 8 years has failed. Then what is the reformative theory? Why it is acting?
My lordship, pardon my lordship, in such antecedents, my lordship,
Item 26.
May I please, Your Lordship?
Yes.
Well, I have filed an application for extension of interim bail, my lord.
Expire kebe korchi?
My lord, next date would be 6th.
6th of December. So for the 2 weeks,
no, this
how much time you are praying, sir?
4 months, my lord.
Months they have.
My lord, से complete कर दो. तार जो allegation है जे flat दे पाओ नहीं से 16 ता complete कर दो दे दो. एटा गुटे.
Spelling, I could not get you, sir. 4 months you are wanting. No, rejected.
3 months.
Be reasonable to the court so that you get some reasonable order.
Up to your lordship, your lordship.
How much time was granted initially?
4 months, 4 weeks. 4 weeks.
कौन से correction जाएगी? What he is doing by going out?
बापांकर operation था ही आनिश्वर.
He should not visit his father. His father is a heart patient. He should avoid meeting his father.
Nobody is there to look after him.
Sir, nobody is required. At least sons like him are not required to be present. Who will give tension to the father? Who will subsequent heart attacks will come.
How can not?
Because father seeing him outside must be frightened. That he doesn't have control. He doesn't have control.
How can not? Your lordship can see answer too.
Sir, those stories are very well drafted stories. But as you heard, Mr. Or Mr. Pal or Mr. Sharma.
Document
Sir, document doesn't help you. Document doesn't help you. Sir, you are the reason your father's heart condition. So shall I record that? Shall I record that? If you want, I can record it. It's not without any
2 months, my lord, possible.
No. 4 weeks. If you can mend your ways, your father will be in a much better shape. I don't know. He will again have to come and file the affidavit. After getting, for you, he will run after the court process. You must think about what you are doing to the father.
He will complete, my lord, he will settle the matter, my lord. He has also given an undertaking, my lord, he will complete the procedure, my lord, and hand over the parts, my lord.
If you have been concerned about your family, you should have been concerned much earlier. Not after in trouble and inside jail.
He is repenting.
Your concern of late. Somehow, I mean, it's not. It may not be a pure coincidence. It has some purpose. You are utilizing your family condition to get bail. That is the sad story. Yes, hard copy on you.
Yes, copy, sir.
Mr. Kirot Kumar Raut for the petitioner, Mr. Jyoti Prakash Patra, Additional Standing Counsel for the State. IA, this is order in IA number?
IA number
1415.
No, this is 1415. Earlier it was
1415 is the paper extension. IA 1415 of 2023. Have you verified that he has not violated any condition, or you are yet to receive that instruction? Because that is important. I have to record that. So I'm calling it today is fast. The surrender date is?
Surrender date is 9. Date of surrender is 6th. He was released on the 9th.
6th is due date.
Yes.
So you obtain instruction. I'm calling it tomorrow.
No.
Okay.
Yes.
You obtain instruction over phone that whether he has complied with the conditions or not. When did you serve the copy?
Today.
Then how he can do it? Then you are not concerned also.
Yes. My clerk.
That shows that how that's concern regarding your family. Of late.
My clerk is hard of hearing, my lord. I asked him, but he could not hear, my lord. He served the copy to the government, my lord, wrongly.
The learned counsel for the petitioner submits that he has served the copy of the affidavit IA today on the learned ASC, who seeks time to obtain instructions as to whether the petitioner has diligently and scrupulously complied with all the terms of and conditions of grant of bail. Let the instructions be provided, be obtained by tomorrow, list on 3rd. Third, you mention in the morning because third will be a truncated hearing. So at 10:30, because wherever there is this kind of a petition, you have to mention it. Yes.
27.
Yes, 27. Let's say quad point.
Miller.
Yes, please, 27.
May I please, Your Lordship? The Lordship, if you accept my dhinama, then I will place the matter because the petitioner is seeking to change his advocate and the
Your name, sir?
are not given the consent.
Your name?
A.R. Machi.
Mr. A.R. Maji submits that he has instructions to appear on behalf of the petitioner after the learned counsel who was appearing earlier has retired from the brief and given consent. Yes.
The petitioner is in custody since 18/6/2023, my lord.
Affidavit have you filed? Or you are under impression that once the lawyer is changed, the order will change. There is no concept of order. I will dictate that since my earlier learned brother has passed an order, I will...
name only one case.
Whatever, sir, you have to comply that order.
Please come this matter tomorrow. File today.
Tomorrow or today, that I am not concerned. But you are not complied that order. But then what is the Okalatnama that will be filed shall be taken on record and name of Mr. Kapara. The Okalatnama filed by the learned counsel shall be taken on record. His name shall be indicated in the cause list as well as the case brief. Name of the learned counsel who were appearing earlier shall be deleted. Learned counsel appearing today for the petitioner seeks further time to comply with the order dated 01.09.2023 to file an affidavit regarding the past allegations of criminal activity against the petitioner, if any, and the stage thereof. And the stage of trial thereof. How much time you require to file the affidavit?
Only 2 days.
The learned counsel, as prayed for, further time is granted to comply with the said order dated 1/9/2023. Copy of the affidavit shall be served on the learned counsel for the state on by 6. I am saying you can serve it today also by 6/11/2023 to enable him to obtain instruction. List on 20/11/2023. Yes.
28.
May I please, Lord?
Say Okalatama dekhan.
28.
Sir, ରଖି ପଠେଇ ଦିଅନ୍ତୁ ଦେଲେ ସେ ଆପଣଙ୍କୁ
ରେକର୍ଡ ଅଛି
ଦିଅନ୍ତୁ ସେଟା where you have filed the Okalatnama?
Not before vacation. After filing of Okalatnama,
the whole problem is you don't realize we have not filed. You are saying that you have filed. None appears for the petitioner when the matter is called to grant another opportunity. You're just wasting time, sir.
my name is reflected in the list.
Sir, then where is the Okalatnama?
My name is reflected in the list.
Sir, you don't have to repeat thrice. I'm asking you where is the Okalatnama? Yeah. नहीं कटंतु What is your name, sir? A.R. Maji.
A.R. Maji.
पूरा अकलतनामा देखाନ୍ତୁ ଏଠି ଜାଗା ଦେଖାନ୍ତୁ जो मोड़ी दौरान सेटा केमती मु पाइबी केमती आप फ्लैग मरा है लिखिले वकालतनामा is already on record. Yes, the order remains the same order.
28.
Yes.
28 minutes a preface of by time for the case diary and the
third occasion.
Obviously, it could be fourth occasion also. Till it happens that only one crime is committed and they are having only one brief, you are having one brief. That is another problem. Actually, that doesn't help the petitioner as far as if the delay is there.
A week's time, my lord, I'll get this.
And the lawyers will not be happy. If there will be only one, then lawyers will not be happy. Mr. Parthasarathi Das for the petitioner, Mr. Devashish Naik, AGA for the state. The learned counsel for the petitioner submits that though earlier a time was granted, the instructions and case diary have not been provided by the state. The learned AGA seeks further accommodation to obtain up-to-date instruction, oblique case diary, oblique criminal antecedents of the petitioner. When do you want, Mr. Naik?
One week time.
As prayed for, list on. Oh. Today's one, na? 4 of them. 13 Mr. Das on 13/11/2020. Yes.
29.
Hon'Ble.
Yes, please.
May I please, Your Lordship?
Yes.
My lord, bring for 1 week time, file the surrender certificate.
Despite the earlier time granted, you are Mr. Nandi,
My lord.
Mr. M. Nandi for the petitioner, Mr. Devashish Naik, AGA for the state. Despite the earlier time granted, on 6/10/2023, the certificate indicating surrender of the petitioner after the period of interim bail was over has not been filed. Stop para. The learned counsel for the petitioner seeks further accommodation to produce such certificate. Registry shall obtain up-to-date instructions, oblique report from the learned court in session of the matter regarding surrender of the petitioner. What is your instruction? He has not surrendered.
Surrender, man. My lord, 22/9/2020.
Regarding surrender of the petitioner, stated to have been made on
22/9/2020.
22/9/2020.
My lord.
Yes. List on
14/11.
or even further time.
14.
14/11. Yes.
30.
Yes.
May I please, Your Lordship?
Yes, please.
The petitioner is in custody, my lord, since 25/5/2023 in connection with an offences punishable under.
The affidavit has been filed.
Yes,
Yes, my lord.
Lordship.
When have you filed?
2 weeks before I have filed, Lordship.
307, my lord, who accused has been released on bail on anticipatory bail.
But he's a celebrity. He is maintaining his activities in 2013 for 10 years.
Not celebrity, my lord. He belongs to Bajrangi group.
No, sir. Don't make political speeches here.
This is the story of political battle.
No.
The story itself, my lord, is political. I am not.
Then I have to dismiss it, sir.
I am not making it.
Sir, you have to look after the welfare of your client,
That's
not
right.
make political speech. I am not interested which group, whatever he's doing. And is it a banned group, banned organization?
No, they are opposing cow slaughtering.
So whatever, sir, cow vigilantism has been strong now. The special statute has been come.
And in course, my lord, there was some hitch, and it is stated that
No,
they have
sir, in the so
307 not named in the FIR. Yeah, my lord, the
no,
injured has
since
also
2013 he is doing this. You have you verified?
Two criminal antecedents. This is a clear case of extortion, and he seems to be in the habit of extorting money from all cattle traders in that area. And this specific incident, as is revealed from everything that is there in the case diary, is because
What is his age?
27, my lord. May I pray, my lord? One prayer.
So 27, he then he's a from his when he was a juvenile, he has started this.
No, my lord. May I pray, my lord? Your lordship, I am serving a copy where this one of the co-accused, my lord, has been granted anticipated bail.
No, sir, I am not impressed with that 438 order, sir. That doesn't help. The criteria is different.
Let him examine, man. Let him examine whether he stands on the same footing or not. Thereafter only.
No, it's not a question of same footing.
B07 already in custody. Investigation complete. Charge sheet has been filed.
Since when? Since when in custody?
In custody since 25/5/2023.
More than 6 months.
More than 6 months.
So the information he has furnished also, is in sync with your instruction. Because he has in Chauliaganj, started 2013 Chauliaganj, then Lakshmi Sagar 21, Bodagada 22, then Bodagada 23.
Charge sheet filed since 18.
He is traveling from Kotak to Soroda. Or what?
The allegations all in the affair is not named in the affair. The injured himself has not named me, my lord. The injured
being aged about 27 years, there is a possibility of he being reformed and is to be shown indulgence by this court. It is further submitted that the petitioner shall abide by any condition that would be imposed for grant of bail. He being a local person shall subject himself to the jurisdiction of the court in session of the matter. Learned AGA, referring to the allegations against the petitioner, the materials contained in the case diary, opposes the prayer for bail. Having heard learned senior counsel for the petitioner and the learned AGA, this court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition that any violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing of petition for cancellation of bail by the law enforcement agency, oblique victim, oblique informant, disposed of accordingly. Yes.
31.
Sorry.
Urgent certificate.
Yes. So it is uploaded. I mean, nowadays everything is uploaded. Yes.
31, my lord.
31.
Pray first time for the case diary.
My lord, the present petitioner was on interim bail, but in the right time he surrendered, my lord. I'm producing the surrender certificate.
Mr. S. Das, you are Mr. Das.
Satyajit Raut.
Mr.
On behalf of Hon'Ble Ratna Ponda.
Mr. Satyajit Raut on behalf of Hon'Ble Ratna Ponda. S. Raut on behalf of A.R. Ponda on behalf of the petitioner. Mr. Devasis Naik, AGA for the state. Counsel for the petitioner submits that in compliance of the earlier order dated 12/9/2023 and 26/9/2023, reiterated on 6/10/2023, is filing the certificate indicating surrender of the petitioner. You are filing that as an affidavit or with a memo?
With a memo, my lord.
With memo dated?
Memo, 2 days memo.
1/11/2023. The memo shall be taken on record. The report of the Learned District Judge Kandhamar indicates dated 30/10/2023 indicates that the petitioner surrendered on 1/9/2023. Yes. So what do you want? Would you love the petition?
No, my lord. Next
So
week we'll
move for regular.
Yes, my lord.
You want case diary? The Learned AG, the as prayed for by the Learned Council for the petitioner list on in December or
Your
when
lords, in next week.
list on
15
he wants further time. List on 28/11
My lord.
case diary and up to date status of trial. Case diary oblique up to date status of trial instructions shall be obtained.
Obliged.
Yes. Hon'Ble Dakot. When the matter reached, and again at 12:30, after it was passed over. As noted above, the victim along with her mother appeared in the virtual Congo AGA for the state. The Learned Council for the the petition has been filed in the year 2010 challenging the judgment and order dated 24/11/2010 passed by the ad hoc additional sessions judge FTC-Roman 2, Fulbani in ST 57 of 2010 oblique ST 183 of 2010. It is fairly submitted by the Learned Council for the petitioner that against the order of discharge, the present petition was filed, and after a lapse of 7 years, nothing would survive for adjudication before this court. Learned AGA, referring to the petition, submits that in view of the prayer made in the petition, the matter has been rendered infructuous. For having held Learned Council for the parties, the petition is disposed of. Yes.
Achor item 5.
None appears for the petitioner, though the matter is called twice over, once at the beginning of the proceeding and again at 12:30. Para. To grant another opportunity, list on
A के बाद.
A के 12.
This also must have been rendered infructuous, my lord.
But I have been educated by all of you.
In this matter, against the rejection of 313 petition, they have come, my lord. In the meantime, if stay order is not there, my lord,
Since no entry,
Stay order is not there in almost all cases.
almost all, my lord.
then it is
And maybe that is the reason they were not looked into by the lawyers, because the lawyers also know that what is the point in listing a matter which has become rendered infructuous. Asian is for his resources or for surfacing. So I'm disposing of.
Again.
Disposing of. Actually? 5. 5. Mr. S.S. Kanungo AGA. তারপর লিখলে the non appearance orderটা দেখলে লিখলে তো appearance and non and S.S. Kanungo. The petition was filed in the year 2011 challenging the order dated 3/5/2011 passed by the so and so দেখি লিখিবে rejecting the petition under section 313 into bracket Roman 1 into bracket capital B of CRPC. Further fact that emerges, the further fact that emerges that though the LCR was called for, there was no interim order staying the further proceeding. The Learned AG, referring to the nature of prayer made in the petition submits that nothing would survive for adjudication after a lapse of 11 years.
11 years.
For adjudication before this court. Before this court. Having heard the learned AGA, the petition stands disposed of. Yes.
7. Item 7.
Petitioner none, Mr. Kanungo AGA for the state. First line same, right? None appears for the petitioner, though the matter is called twice over, once at the beginning of the proceeding and again at 12:30. To grant another opportunity to the petitioner, list on. We are in November.
Right.
This is AP Bosina appear. List on 1411. Here, what is the nature of prayer, Mr. Kanungo?
Malad, somehow my file
Okay.
I'm
List on 1411.
yes, because but this also is a case, if I remember correctly, about 133 promulgation with regard to property of Bardhan Puri.
Oh, so that has been now
nahi obsolete.
Subject matter is no more there.
No more there. Kintu mu file ta hatat nahi.
No, Mr. Bose, I think he will come.
What adjournment de. File ta mu
Directed partial demolition. So now that project is almost complete.
Ha. Seth pe koi lega.
Sri Khetra project is complete now. In fact, the Ekamra project is also now.
Yes, I got the file, my lord. After that, Ekamra Bhubaneswara Saryaka was my lord, give one adjournment there.
Yes. List on केबे को रख लेंगे 14 yes.
Password item 8.
Anyone on behalf from the chamber of Mr. Bose, AP Bose? Yes. Eight. Petitioner none, Mr. S.S. Kanungo AGA for the state. First paragraph of order, same. Second paragraph, to grant another opportunity, list on 1311. Yes. Mr. Senapati was sitting here, AU Senapati, or he was not there. Yes, next.
Item 13.
Petitioner none. Mr. S.S. Kanungo AGA for the state. None appears for the petitioner. When the matter is called. Though the matter is called twice over, repeat that paragraph. Here it is being adjourned since 17/4/2023. What to do?
Multiple adjournments because of the huge quantity. So I leave it to one more chance be given thereafter.
To grant further opportunity, same order कर देवे. Date कर दियो तो सही. 13 week रे कर दियो. 13/11. Yes. Sub item also
same.
Yes, next.
Password item 18.
Thank you. It in same order. None, Mr. Debasis Naik AGA. None appears, though the matter is called twice over. Once at the lecture paragraph likhive. To grant another opportunity, list on 1411. Yes, next.
19.
Same order. Same as 18. Yes. Appearing counsel. Yes. Yes, next. That it is passed over or? Mr. Nayak?
May I please?
Yes.
Initially, 160 was statement. I'll pass it over.
Yes. AGA produces the case diary. Kebe, Mr. Sahoo?
2 weeks.
As spread for in the week commencing 18th week re 18th week re rahebo November no sorry mo December
15 question on 15
15-11 yes
33
Lordship paper pass over.
it will be called again at 2.
Lordship.
Yes.
Obliged.
Yes. Next.
34
34, my lord. My lord. Due to some requirement documents, my lord. One week after, my lord. 11 documents, my lord, not received, my lord.
You are Mr. Misra.
I am Mr. T.K. Sahoo.
Mr. T.K. Sahoo for the petitioner, Mr. Standing Tapas Kumar Pradha, Standing Counsel.
City is there.
For the state. The learned counsel for the petitioner seeks further time, though it was granted earlier. As spread for list on, how much time, sir?
1 week after, my lord.
Date karantu.
15.
15 rahile habo. Kon to sabu 15 kon rakhli. 15 11 20 23.
My lord.
The learned standing counsel submits that case diary is available. Yes. Next.
35
Obliged, my lord. DLS Barango.
Please wait. Please wait. Mr.
35, my lord.
You are Mr. Ashok Das.
I am on behalf of Ashok Das, my lord.
So what's your name, sir?
M.R. Das.
Mr. M.R. Das for the petitioner. You have power here.
Yes.
Mr. M.R. Das for the petitioner. Mr. Standing counsel for the state. Mr. Kamal Lochan Das. You are for the legal aid for the victim.
Yes, my lord.
Mr. Kamal Lochan Das for the Kamal Lochan Das for the informant. Hybrid mode likhive. The learned counsel for the appearing for the victim being present at the virtual court, Odisha High Court, being present in the High Court of Orissa, virtual court, Ganjam at Berhampur, addresses arguments. Yes, what you are saying, sir?
In this case, what has happened? Earlier, CRLA was filed. Subsequently, it was converted to BLAPL, my lord. After conversion, my lord, the file has been misplaced in the office, my lord. Your lordship may kindly 2 weeks time for reproduction of the file, my lord.
When office of your office or
yes, our office.
So whenever a BLAPL is converted, it will be misplaced or what?
No, sita
Among the data thako khojibe, CRLA thako khojibe, BLAPL khojibe. Etre kono that course, etre court apang assist karibo.
Thereafter 3 dates have gone.
File to hoji laga mo I don't have. Apang korin file good data hoji salani. Hoji. Your files also. Now he's in the for the informant side. Usually Mr. Das is appearing for the accused, but today is for the informant. The learned counsel for the petitioner submits that he may be accommodated as the case brief has been misplaced, so as to enable him to reconstruct or retrieve the same. Kebe chahunchanti?
1 week after asu tar bhitar ame kar dete.
As spread for list on 16/11/2023. The learned standing counsel submits that case diary is available. 16/11, Mr. Das.
Yes, my lord.
36
My lord, this is a case of offense under section 363, 366, 376, 2N, 376, 3 of
I'm sorry, your name is?
Satyajit Raut.
So Satyajit Raut on behalf of A.R. Ponda. S. Raut on behalf of A.R. Ponda for the petitioner. Mr. Praharaj, standing counsel for the state. Anyone present for the informant?
My lord, that report has come. Intimacy.
Okay. Then that is there, but usually what is happening once we inform the DLSA, they are appearing.
appears,
They are
my
appearing. Like today the case, I think otherwise the Hon'Ble case would not have happened.
Yes, yes.
Where they are coming from interior place.
It reveals from the, my lord, but it was this grievous. 4 persons sustained injury, out of them 3 is simple, and 1 person has got grievous injury, and his dying declaration was recorded. My lord, that means, my lord, he was not in a condition to.
Obviously.
My lord.
Grievous injury at what place?
My lord, that lacerated wound and work stepped 6 cm, 2 cm, 2 cm, and posture part of the scalp, my lord, and protruded to occipital lesion. And my lord, the 2 cm into 1 cm, themes right finger.
Present health condition asini.
That has not come.
Mr. S. Mohanty for the petitioner. Mr. T.K. Prahara, standing counsel for the state. The learned counsel for the state seeks further accommodation to obtain up-to-date instructions in terms of the earlier order dated 17/10/2023 regarding the present health condition of the victim, injured victim. How much time, Mr. Praraj?
My lord, your lordship, 1 week.
As prayed for. List on 11. Sorry.
Your lordship may indicate that Onnam Muduli, that is the
10-11
name, 4 person injured. Your lordship may call for the health condition of Onnam Muduli.
You call about everyone.
Yes.
Because it will be called by your office.
Yes, ma'am.
Yes. Yes, Mr. Mohanty. You have any difficulty for 10th or 14th?
Not 10 million, on 13.
13-11. Yes.
38. May I please your lordship?
Yes.
Lordship kindly see last order, my lord.
Yes.
Though
file that affidavit.
Though I have already sought a copy of the comprehensive affidavit to my lord and state council as well as my friend for the informant, but I could not able to file.
You have not filed. Mr. K. Pradhan for the petitioner, Mr. Mr. T.K. Praharaj, standing counsel for the state, Mr. M.S.Sahoo for the informant. Learned counsel for the petitioner submits that he has served the copy of the affidavit indicating the past allegations against the petitioner on the learned counsel for the state to enable him to obtain instruction.
Your lordship earlier directed.
Sir, you have
as for criminal answer, no criminal answer. As for
Yes.
our record.
The affidavit, maybe inadvertently, he has not been able to file in the registry and seeks leave to file it today. Yes. Yes, what do you say, sir?
My condition is serious, my lord. He is going open heart surgery. Thereafter, he come. All on a sudden, while he was in driving the auto rickshaw, my lord, all on a sudden he has came and stabbed him. Thereafter, my lord, again now another FIR has been lodged. While he is in custody, my lord, engage another person to compromise the case. Otherwise,
That is afterthought. That is
this is the FIR I have lodged.
That is afterthought, my
Your lordship kindly peruse, ma'am.
You serve a copy on the learned counsel,
Yes, ma'am.
standing counsel to obtain instruction. The learned counsel appearing for the informant submits that there has been some subsequent incidents for which the bail should not be granted.
I may be also
the copy of the FIR, copy of such incident. Sorry, the narration of such incident contained in the FIR has been served on the learned.
The written report I have
learned standing counsel to enable him to obtain instruction.
Yes,
may I permitted to copy? May I permit?
ଆପଣ କଣ କରିବେ? ସେ ଆପଣ ତାଙ୍କୁ କହିଲେ ସେ ଆଉ ଜଣେ ଲୋକଙ୍କୁ ଏନଗେଜ କରିବେ, ତେଣୁ କାହିଁ ସେଟା ନଉଛନ୍ତି?
କମ୍ପ୍ଲିଟଲି ଆଫ୍ଟରଥଟ୍।
ଆପଣ ବେଶୀ ପ୍ରୋଆକ୍ଟିଭ ହେଲେ ସେ ଅସୁବିଧା ହଉଛି। ସେ ଆପଣ ଯେ ଓକିଲ ଯେତେ ଚେଷ୍ଟା କରିବେ ସେ ତାଙ୍କ ବେଲ କରେଇ ଦେବେନି ପିଟିସନ। Saying is well
Because
taken.
of sound propagation.
I understand your submission that it may be afterthought. It is just possible.
What my
Sir, no one is rejecting your contention.
Multiple stabbing injury.
এটা মিস্টার সাহু আপন করুনাহান্তি তো সেকেন্ড
Nine,
থার্ড
nine,
ফোর্থ এফআইআর
Nine.
Nothing, my lord. He is inside the custody in 307 cases.
Sir, that is what he is saying.
My
Being
lord.
in custody, he has informed some persons to intimidate him to compromise. ସେ କୋଉଠି କହିଲେ ଯେ ସେ କଷ୍ଟଡିରୁ ବାହାରକୁ ଆସିକି ଧମକଉଛନ୍ତି ବୋଲି ବା ମୋବାଇଲ ଫୋନ ୟୁଜ କରୁଛନ୍ତି ଯୋଉଟା କି ସେ ରେଡ୍ କରିବେ ତାପରେ
ସବୁ everything is after thought, my lord. Charge sheet submitted.
How much time, Mr. Standing Counsel?
My lord, dear lordship, may give us 2 weeks time, my lord.
As prayed for list on 1511.
Yes, sir.
1511 up to date instruction case diary shall be obtained by the learned standing counsel.
Oblige.
39.
Mr. Pradhan, I have granted you liberty to file the affidavit in registry.
So, yes, my lord.
That I have recorded.
Yes, my lord.
Yes.
Just now.
So don't miss it again.
No,
Yes.
just now I am filing.
Yes.
Item 39.
Call again at 2. Yes.
40.
Very clean lordship.
40, I am appearing for the informant.
Informant.
Offense is 341, 294, 323, 325, 375, 307, 307,
Highest punishable offense. What is the punishment?
307, my lord.
That affidavit copy, my lord, not given. Affidavit.
ଦେଇନାହାନ୍ତି
My lord,
instruction ନିଅନ୍ତୁ
Injuries are grievous, habitual offender. Investigation is going on.
Political hostility between parties, my lord. And you are already discharged within 2 days of occurrence, my lord. And grievous injury on leg, my lord.
There are 3 petitioners. I think affidavit has been filed in respect of 2 petitioners. my lord.
ନାଇଁ ତିନିଟା ଯାକ ହେଇଛି ଗୋଟେ ଦେଇଛନ୍ତି କମଳା ପଣ୍ଡା ଆଉ ଗୋଟେ ଦେଇଛନ୍ତି ବବିତା ଭଞ୍ଜ ଆଉ ଗୋଟେ ଦେଇଛନ୍ତି ପରୀକ୍ଷିତ ରାଉତ
ମୋର ଦିଟା ଅଛି
Mr. Mulia, when did you serve the copy?
Tomorrow, my lord.
ନାଇଁ यार ଆପଣ before vacation ଦେଇଥିଲେ
Yes.
Mr. S.R. Mulia for the petitioner, Mr. Standing Counsel for the state, Mr. S.R. Mahapatra.
Yes, ma'am.
ଓ ସତ୍ୟଜିତ ଆପଣ ମୁଁ କହିଲି S.R. Mulia, S.R. Mahapatra ରାଇମିଂ ହବ ତ ବେଟର ହେଇଥାନ୍ତା ସତ୍ୟଜିତ ଆପଣ ମୁଁ ସତ୍ୟରଞ୍ଜନ କରିଦେଲି Mr. S. Mahapatra for the informant. The health condition ଭଲ ଅଛି ତ?
No, no, bed ridden lordship is a habitual offender. Investigation is going on.
After 2 days, my
ଆପଣ
discharge.
ସବୁବେଳେ ତ ଆପଣ ଫେର ଏପଟେ ବେଶୀ ଆଉ ରହୁଛନ୍ତି ନା ଆପଣ ଏମିତି ଆଉ କହିଲେ କେମିତି ହବ? Mr. Counsel for the petitioner submits that he has filed affidavit on behalf of all the 3 petitioners through their respective relatives, indicating the past allegations of criminal activity against the petitioners. The learned standing counsel submits that ଆପଣଙ୍କର କୋଉ affidavit ଅଛି? କମଳା ପଣ୍ଡା ଅଛନ୍ତି?
କମଳ ପଣ୍ଡା ଅଛି
ବବିତା ଭଞ୍ଜ?
ଆଜ୍ଞା ସେଇଟା ଅଛି
ପରୀକ୍ଷିତ ରାଉତ?
ନା
Submits that
in respect of petition number 3 not
in respect of petitioner number 3, Benuranjan Raut, the affidavit of Sri Parikhita Raut, father of the petitioner, copy of the affidavit filed by the father of the petitioner may be served on him so as to enable him to obtain instruction. The learned counsel for the petitioner submits that he shall submit a copy afresh by tomorrow. List on 1511. Yes. 1611-2023. The learned standing counsel shall obtain up-to-date instructions in the matter. Yes, Mr. Mulia.
41.
Starters of Armageddon.
Sir, also, which shall include the health condition of
Yes,
the
since 161 statement has been
statement has been
recorded.
recorded. Include the status, the health condition of the victim, injured, the health condition of the injured in the occurrence. Yes. Yes.
Item 41.
41, I pray for adjournment, my lord.
Mr. Nityananda Mahapatra for the petitioner. Mr. Standing Counsel for the State, Learned Counsel for the petitioner seeks adjournment.
2 weeks after 21.
As prayed for list on. Yes, Mr. Barik.
21, my lord.
21. 21/11/2023. Cities. The Learned Standing Counsel submits that case diary is available. Yes.
42.
May I please, Your Lordship? I am in BC Pro. May I please, Your Lord?
Yes. Mr. Manoj Naik for the petitioner, Mr. Standing Counsel for the State, the Learned Counsel for the petitioner being present at the virtual court, High Court of Orissa, Khurda at Bhubaneswar, addresses arguments. Yes, please. Yes, Mr. Naik.
May I please, Your Lordship?
Yes.
That is, I have challenged the rejection order, annexure under annexure 2. The petitioner was initially arrested on 18th.
You file an affidavit. What is the nature of allegation? How much money? Total money?
1 lakh only.
1 lakh. That rejection order itself shows page 2. Further, it reveals that alleged phone number
21.
Yes, sir.
The Learned Counsel for the petitioner submits that he shall file an affidavit indicating the past allegations against the petitioner.
21 number of say.
No, that I was telling Mr. Naik. Mr. Naik is only looking at the screen.
That is, I have
Now we
also
are in a different
another
environment.
other cases is in bail.
Yes, kindly listen that. In fact, that I am dictating. All likely. Petitioners regarding criminal activity and the status of each case, so as to seek indulgence from this court for grant of bail. Mr. Naik, you filed that affidavit giving the list of all the cases and the status.
My humble submission, in respect to Bhubaneswar, there are 2 cases only. One case is presently
Bhubaneswar, or now there will be plot will be sold in Moon also. So how does it have a bearing on this 439 petition? You file the affidavit and serve a copy. You do your job as a lawyer.
I obliged.
How much time you will require, Mr. Naik?
At least was 1 week.
As prayed for, list on. As prayed for, the affidavit be filed by 14/11. Copy be served on the Learned Standing the Counsel for the State to enable him to obtain instruction. List on 21/11.
Regarding
sorry,
regarding my lord, regarding all the
yes, by a relative of the petitioner giving all the details.
Another case about this present petitioner bearing BLA.
See, unless you ask them or you have this order, they will not contact you or they will not listen to you. So let them do that and serve a copy.
I obliged.
The Learned case diary is available, Mr. The Learned Standing Counsel shall obtain the up-to-date case diary and instructions in the matter. You file it by 10 next week. Yes.
43.
Yes, madam.
Please, item 43 next week, my lord.
I just forgot your name. Please kindly tell your name.
Saraswati Senapati.
Ms. Saraswati Senapati, MS. Saraswati Senapati, on behalf of Tukuna Kumar Misra for the petitioner, Mr. Standing Counsel for the State, Learned Counsel for the petitioner seeks accommodation to advance arguments as prayed for. List on. ଆପଣ ଯଦି 1 week ଚାହୁଁଛନ୍ତି ନା କେତେ?
Yes, ma'am.
List on 17/11/2023. Case diary is available. The learned standing counsel submits that case diary is available. Yes, next.
44.
44.
IE, MC, here MC. 84 of 2006. Mr.
Notice.
Standing counsel for the state.
My lord, appear କରିଯାଇଛୁ. My lord, someone has appeared.
Pursuant to the notice issued on limitation, learned counsel Mr. P.R. Singh has appeared on behalf of OP number 1 and 2. None appears for the opposite party when the matter is called. To grant further opportunity, list on.
Charibar.
Or you can call again at 2, since it is already 1:15. So maybe so rest of the matters after recess.
Item 33.
May I please, Your Lordship?
Yes.
Instruction was.
My lord, I have submitted one instruction, 2-page instruction on the investigation.
That is on record.
No, today I have submitted. Yesterday night I got.
So it is that she has withdrawn the amount.
Yes, sir.
No, withdrawn doesn't mean who has authorized the withdrawal.
Well, since you are the my lord, headmaster in charge, my lord, she can withdraw, my lord. In the next page, your lord, during the course of investigation, examine the complainant and other witnesses. According to the statement under section.
Yes, this final prosecution report has been filed.
Not filed.
Kitne दिन हेलानी?
Custody 27/7/23.
120 days complete ही नहीं?
No, my lord.
Not completed. Let her deposit some amount and go, my lord. Lord, on the last occasion, your lordships.
No, I remember that. Yes, Mr. Baran, what is your instruction?
My lord.
Apparently, she has withdrawn.
Yes, but that is admitted fact, your lordship.
So, where is the money now?
Money, your lordship, utilize it for the purpose of the school.
Arey, sir, don't say that it is utilized.
My lord.
Arey, what records or what evidence you have to show that? Records kaun achi, sir?
Record available in the school, your lordship.
Sir, what is that, sir? Apno record available in the school. Sun rises in the east.
The school
sun sets in the west. Or kaun
yes,
mane achi?
no, my lord. That is the record is available in the school. What I got instruction from her husband, your lordship.
Are you aware how government money is spent? As a counsel, are you aware? Or your client will fool you?
No, my lord.
So there is a concept of cash book, voucher, receipt.
Yes. Every
so where is that?
That is in school, your lordship. The fact, your lordship, if your lordship permit me 2 minutes, I will.
Sir, you have been permitted, but you are going haywire.
No, my lord.
You are not permitted to go haywire, submit anything that everything is in school, spent for school. So what is there to show your bona fide?
Seta school le achi. Mu sei kotha ta kahuchi lo.
Seta kon ta school re achi. What is that?
Passbook, cash book, everything.
Passbook re you are
allegation
following, sir. Passbook, checkbook,
my lord.
Deposit slip are for the bank.
Yes.
For expenditure, it is something else.
Yes. Cash book.
Cash register, cash book, voucher.
My lord. The allegations, lordship, for a moment, page 10, it is further submitted that as on date of for taking over charge of the school, that is 7/7/15, the balance in the account was.
Mr. Baral, you are either you are not prepared or you are not following. Two things. Have you realized what is the offense? Alleged?
Yes, lordship.
She is presumed to be innocent. So what is that offense? But what is the overt act alleged to him?
Overt act, lordship, the allegation is that a cash book, passbook, and a check register regarding transaction of the amount have not been handed over to the school by M.S.Sahoo till date. That is the allegation, lordship. The allegation is not there. I have misappropriated the money.
That is the problem. You have not understood the case at all. That shows your level of preparedness. You have not understood the case at all. With greatest of respect. They have seized the checks which you have deposited in the bank to withdraw the money.
Yes.
Which contain your signature.
Yes.
So that is the prima facie case.
That has been used since 2015 to 2017 in my tenure. I have withdrawn the money and utilized in the construction of.
Sir, the dates are very specific.
Yes.
Dates are very specific. The dates are very specific. So corresponding cash register has to be maintained.
Yes, sir, lordship. That is there in the school.
So when you have, withdrawn the money.
Yes.
From 2015.
My lord.
You do not know what has happened to the money.
The money, uthila school camera lage building construction, building construction.
Sir, this is not some katha that going on that you will repeat on repeating the same thing. Money school camera lagila, money school camera lagila. This is not. Chalini prabhachana gote nuho je apna gote chalibe. Apna jodi buji parnanti, then you better retire from that you cannot deny because They have seized the checks from the bank.
ମୁଁ deny କରୁନି.
So and what happened to the money? Whether you have kept any
money instruction ହଉଛି ଆଜ୍ଞା ମୁଁ ହେଡମାଷ୍ଟର ଥିଲା ବେଳେ ଯାହା ସ୍କୁଲରେ ଖର୍ଚ୍ଚ ହେଇଛି ମୁଁ ସେ ପଇସା ଉଠେଇକିରି ସ୍କୁଲ କାମରେ ୟୁଟିଲାଇଜ କରିଛି ସେଥିରେ କ୍ୟାଶ ବୁକ୍ ରେ ଏଭରିଥିଙ୍ଗ ଇଜ ଡକ୍ୟୁମେଣ୍ଟ ଇଜ ଦେୟାର ଇନ ଦ ସ୍କୁଲ ଲର୍ଡସିପ but fact your lordship since 2017
say he will not understand or he is not in a mood to understand. Mr. Standing Counsel, you obtain instruction what has been seized from the school regarding the cash book and other expenditure. He will not understand.
ମୁଁ ତ କହିବା ପାଇଁ ଚାହୁଁଛି ହଜୁର allow to know that the some misappropriation and corruption is going on in the school regarding appointment of school peons, everything, your lordship. That I have written to the DO and other authorities regarding that corruption. Making on that when the authorities inquire about the matter, the DO and other officials against teachers, they have lodged an FIR against my husband. Though there was I was the only staff in the school at that time, teaching staff, your lordship. Thereafter, 7/9/17, there is a Bhanjanagar police station case number 274 of 2017 has been registered against my husband. And subsequently that has been ended with final form, your lordship. No case made out. Thereafter, lordship, due to that FIR, your lordship, I was on distress and I suffer from illness. Then I was leave on the school since 8/9/17 to 30/11/17 and join in the service on 1/12/17, lordship. Thereafter, lordship, on 26/6/18 I joined in the school. Then since then, your lordship, 1/12/2017, the DO, one Nishakar Nayak in my place, she has been deployed. One Nishakar Nayak as in charge of headmistress, your lordship. Since then, I have not been allowed to perform my duty as headmistress in the school, for which I have filed a writ application before this honorable court. And in that writ application, the authorities have filed counter. I have also annexed Annex 3 as that counter, lordship. After he has been taken the charge as headmistress in my place, page 67, lordship, I have annexed they have make an inventory through the Tahsildar, lordship. And in inventory, they have taken away all the documents, whatever available in the school. So far, the cash book, cash transaction, everything is there, lordship. That is in the school. And since 2017 till date, I am not in the school and they are managing the school, lordship. So the present allegation in the FIR, lordship, kindly have a glance. Though I have not producing the cash book and passbook and check register is not available in the school, then they have lost this FIR. ଯେହେତୁ ସେଦିନ ଡକ୍ୟୁମେଣ୍ଟସ ନାହିଁ ସେଥିଲାଗି ସେ ପଇସା ଉଠିଛି କୁଆଡେ ଯାଇଛି ଆମେ ପାଉନୁ. ଦ୍ୟାଟ୍ ଇଜ ଦ ଆଲିଗେସନ, ଲର୍ଡସିପ୍. ସେଥିରେ କୋଉଠି ଲେଖା ହେଇଛି ଯେ ମୁଁ ଆଜ୍ଞା ପଇସା ନେଇକରି ଅଦରୱାଇଜ ଖର୍ଚ୍ଚ କରିଛି କଣ କରିଛି. ତେଣୁ ସେମାନେ ତହସିଲଦାରଙ୍କ ମାଧ୍ୟମରେ ଇନଭୋଟରୀ ଯେହେତୁ କରିଛନ୍ତି ତେଣୁ ତାଙ୍କ ପାଖରେ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି, ସେମାନେ ବେଟର ପ୍ରୁଭ କରିପାରିବେ ପଇସାଟା ଉଠେଇକରି ମୁଁ ସ୍କୁଲ କାମରେ ଖର୍ଚ୍ଚ କରିଛି କି ମୁଁ ନିଜେ ଖାଇଛି କଣ କରିଛି. ସେ ଜିନିଷଟା ଆଜ୍ଞା ସ୍କୁଲରେ ଆଭେଲେବୁଲ ଅଛି. ଇନଭେଷ୍ଟିଗେଟିଂ ଅଥରିଟି ସେ ଜିନିଷଟା ସେଠୁ ପାଇକରି କହିପାରିବେ କି ଯାହା କହିବେ. ମୁଁ ଆଜ୍ଞା କଷ୍ଟରେ ରହିଲି. 17 ମସିହାରୁ ମୋର ଚାକିରି ନାହିଁ, ମାନେ ମତେ ଆଲାଉ କରୁନାହାନ୍ତି. ମୁଁ ରିଟ୍ ଆପ୍ଲିକେସନ ଫାଇଲ କରିଛି, ରିଟ୍ ଏଇଠି ପେଣ୍ଡିଂ ଅଛି. ଲାଷ୍ଟ 27/7 15 ମସିହାର ଅକରାନ୍ସ ପଇସା ମୁଁ ଉଠେଇଛି 15 ରୁ 17 ଭିତରେ. 18 ମସିହାରେ ତମେ ଇନଭେଟରୀ କଲ. ଇନଭେଟରୀରେ ଯଦି ମୋର ପାସବୁକ୍ କ୍ୟାଶ ବୁକ୍ ମିଳିଲାନି କି ମୁଁ ଯାହା ପଇସା ଉଠେଇଛି ଯଦି ସେ ବାବଦରେ କିଛି ଇନଫର୍ମେସନ ନ ମିଳିଲା ସେତେବେଳେ ବି ସେମାନେ ଏଫଆଇଆର ଦେଇ ପାରିଥାନ୍ତେ. 17 ମସିହାରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଏଫଆଇଆର ନ ଦେଇ 23 ମସିହାରେ ଆଜ୍ଞା ଗୋଟେ ଡିଓ ଗୋଟେ ଇନଫର୍ମେସନ ଦେଲେ, ବେସିଂ ଅପନ୍ ଦ୍ୟାଟ୍ ଇନକ୍ୱାରି ଦିସ୍ ଏଫଆଇଆର ହାଜ୍ ବିନ୍ ରେଜିଷ୍ଟର୍ଡ. କୋଉଠି ଏଥିରେ ଲେଖା ହେଇଛି ଆମେ ଯେହେତୁ କ୍ୟାଶ ବୁକ୍ ଆଭେଲେବୁଲ ନାହିଁ ସେଥିଲାଗି କହୁଛନ୍ତି ପଇସା ଉଠେଇଛି ସେଟା ମୁଁ ମିସଆପ୍ରୋପ୍ରିଏସନ କରିଥାଇପାରେ. ତ So 17 ମସିହାରୁ unnecessary the one lady headmistress has been harassed by the authorities. ସେମାନେ ମତେ କାମ କରିବାକୁ ଦେଲେନି, ମୁଁ ଯାଇକି DO ଅଫିସ ଆଗରେ ଗୋଟେ ମାସ ପୁରା ଧାରଣାରେ ବସିଲେ, ସେଠି ବି ତାଙ୍କୁ କିଛି କରେଇ ଦେଲେନି। ଏବେ କହୁଛନ୍ତି ଯେ ମୁଁ ପଇସା ମିସଆପ୍ରିହେନ୍ସନ କରିଛି, ସେଥିଲାଗି କେସ୍ କରିକି ମୁଁ ଆଜ୍ଞା ଗୋଟେ ଲେଡି about 59 years lordship 27/23 ରୁ କଷ୍ଟଡିରେ ଅଛି। That is the fact, lordship.
Yes, anything else?
No, my lord.
Since the learned counsel for the petitioner submitted that he is not being heard in the matter or not being given opportunity. After he started arguing around 2:20 p.m., a specific time slot was granted to the learned counsel from 2:28 p.m. to 2:33 p.m. to address the court regarding the merits of the case. The essential submissions of the learned counsel for the petitioner is that all the documents are in school. She has not committed any offense and spent the money. Only for the requirement of the bona fide requirement of expenditure for the school. On being specifically asked whether any prima facie material is there, like cash book, voucher, cash register, to indicate that she has spent the money, the petitioner has spent the money for the purpose of requirement of the school. The learned counsel for the petitioner, apart from saying that he is not given any opportunity to say anything, has not brought anything before this court, not stated in the petition regarding any indication, regarding any documents to show that in fact the money has been spent for the requirement of the school. Yes, Mr. Praraj.
Yes, my lord, may kindly see page 11 of the brief, my lord. That is the part of the FRA, lordship. In this connection, it is submitted that due to non-handing over the school records by the the petitioner, an inventory was made on 35/2018 on the instructions of the then collector and DM Ganjam in presence of Tahsildar.
The learned counsel for the learned standing counsel refers to the specific instructions issued from the district education officer, which is part of the FIR.
Yes, my lord. Page 11.
That is letter office letter date number 6024 dated 4/4/2023 to the address to the superintendent of police, wherein it has been stated that when the inventory of the school records was taken as per the instructions of the collector and district magistrate Ganjam in presence of the Tahsildar and executive magistrate Belagunta, the records such as cash book, passbook, check register, and all other relevant documents relating to cash transaction could not be recovered, and the fact was intimated to the Directorate of Secondary Education as well as Government in School and Mass Education Department. It has been further stated that the petitioner was requested to attend the office of the district education officer on 2/1/2023 with all relevant records in support of disbursement of the amount. Which the petitioner did not respond. Upon respond kale? Upon jo record cash book voucher cash book ne jiba pe kuha gala respond kartile?
Tanku kichi letter asini.
The learned counsel submits that he has instructions that the petitioner has not received any letter. It is further stated in the said letter to the Superintendent of Police that the cash book, passbook, check issue register and other documents relating to cash transaction were not handed over to the present in charge headmaster, Sri Nisakara Naik. Only from the acquittance register, the payment of family pension to Sri Kedarnath Pradhan up to October 2012 could only be ascertained. Para. In the instruction received from the concerned investigating officer, investigating agency, that is letter dated 31/10/23 from the IIC Belagunta, it is indicated that for the period from 7/7/2015 to 7/9/2017, amount kept in the bank account of the school has been withdrawn by the petitioner on different dates, such as देखिए लिखिए 12/10/2015 rupees 2,76,721 up to 1/12/2017 rupees 78,000. The total amount withdrawn comes to rupees 6,89,721. It is alleged that the amount misappropriated, that is government, that is cash, that is government money, it is further alleged that a cash of rupees 7,12,721 has been misappropriated. It is further stated that the original checks on which the amount of rupees 5,13,721 was withdrawn by the petitioner has been seized The Learned Standing Council shall obtain further instruction regarding instructions from the investigating agency regarding the cash voucher, public cash register. Now, I understand that it has not been handed over or it has not been seized. But you obtain specific instruction.
Thereafter, he went on unauthorized leave, till today he has not joining and not submitting. If he has spent and kept he has the custodian of the record, he has to hand over all those things. She has not handed over till today. And in order to take a plea of alibi, he is stating all those pleas before this honorable court at the, on the 439.
Before this honorable court, you have heard Mr. Baral. Actually, he has, apart from saying that the court is not hearing him, he has said nothing.
With great respect, pardon for that. case ta jaha mu to seta fact hajur ko kahibi lokale kemti janibe
hajur apanku to mu se katha kahuchi ଆପଣଙ୍କ presumption in inventory after that it has happened. It's not that after something has happened and they have made inventory. It is the other way around. After the inventory, since the cash book was missing from the school, they have lodged an FIR. And now things have taken this turn.
18 ଆଜ୍ଞା ଇନଭେଣ୍ଟରି କଲେ 23 ରେ ଏଫଆଇଆର ଦେଲେ
Sir, that is the problem. Author inventory ରେ ସେ record ନଥିଲା. That is against the petitioner, not in favoring the petitioner.
ଏଣ୍ଟାର ଅଥରିଟି ଲାଗି ଯାଇଛନ୍ତି ଗୋଟେ ଅଫିସର ବିରୁଦ୍ଧରେ 17 ମସିହା ମାନେ
ହେଇପାରେ
that is
again the whole world is bad possible, but as far as 439 is concerned, it is a provision of law.
Yes.
So I also bow down that I cannot observe that the whole world is bad. It is also submitted by the learned counsel for the petitioner that the entire official machinery is against the petitioner. In considered opinion of this court, such a submission is to be rejected, being bereft of any basis. Yes. Anything else? And the other part is that just in leisure, since it is a live proceeding, you watch it. I hope you will appreciate that whether the court said something which is so so inconceivable, you can watch it also in your leisure, because you will not be in the mood to argue. You can watch it also. This proceeding is a live proceeding. You can watch it. Yes, what do you want?
One chapter in detail or something.
Yes, Mr. Barik.
17
will be fine.
Minor.
As prayed for by the learned counsel for the petitioner, list on 1711. The learned standing counsel shall obtain up-to-date instructions regarding the submission of the learned counsel for the petitioner, that all the records regarding expenditure is available in the school. Yes.
That's over item 39.
Yes.
On behalf of S.K. Mahanti, kindly adjourn to.
What is your name, sir?
Sujit Satpathy.
Sujit Satpathy. So Sujit Satpathy on behalf of S.K. Mahanti for the petitioner. The learned counsel for the petitioner seeks further accommodation, though it was granted earlier. As prayed for, list on. When do you want?
Next week.
10.
Those will be fine for you, or further time.
Next week and
10/11/2023.
Madam.
The learned standing counsel submits that the case diary along with the statement of the victim is available. Under 164 statement is available.
Nice.
Yes.
Item 44.
Yes.
Notice has gone on limitation. Someone has appeared, madam. Mr. Singh has appeared.
44 order doka hitla bodhe.
Detail doka.
Okay. None appears for the petitioner, though the matter is called twice over.
Not as a OP. I'm
sorry, Mr. Standing Counsel for the state. Opposite party, none. None appears for the opposite party, though the matter is called twice over. Once before the lunch break, again after the resumption of the court proceeding. To grant further opportunity to the opposite party. To grant further opportunity, list on 4/12 or earlier, 4/12/2023. Yes, next.
45.
Not filed. I'll
The Standing Counsel for the petitioner, opposite party, blank. The learned counsel for the petitioner, the learned counsel, learned Standing Counsel for the state submits that due to inadvertence, the requisites for issuance of notice on the question of limitation could not be filed. He seeks for further time. As prayed for. Prayer is allowed for the 1 week time is granted for filing of requisites for issuance of notice to the opposite party. This is miss case number 50 of 2006. But here again, limitation has been, this is 40, this is 71, but limitation notice has been issued.
My record also showed requisites filed.
Our registry has also, I mean, I don't understand what they are doing. कौन लिख ले? Go through the entire order. Mr. Standing Counsel for the state, opposite party, blank. The learned, the registry has put up a note dated 21/2/2011 that notice in limitation matter issued to sole opposite party through serving court fixing 15/2/2011 for appearance and show cause. Apparently, the said noting is after the noting that requisites for issuance of notice on question of limitation not filed, that is dated 31/10/2023. In view of somewhat divergent notes put up by the registry, the court is not in a position to ascertain whether requisites have been filed or not. The learned Standing Counsel seeks liberty to take notice afresh to the opposite party by registered post with AD in the present correct address. Prayer is allowed. Let requisites for issuance of notice by registered post with AD be filed within 3 weeks. Well, list after SR.
Item 46.
Same thing. Here also we have filed it.
46 same. Though it has been indicated in the cause list that 46 requisites for issuance of limitation notice not filed. which is apparently pursuant to the office note dated 31/10/2020. 31/10. This is dekha jauni. 31/10/2023. The earlier office, अच्छा आपण कौन करचंती पण ऑफिस नोट न देखि कि लिख दैछंती
सेटे भूल दिस
ते ऊपर ऑर्डर से है भूल नोटिंग दैछंती office note office note dated 31/10/2023 put up by the registry. The earlier note dated 21/7/2011 indicates that notice in limitation matter issued to the opposite party number 1 and 2 through serving court fixing 28/8/2011 for appearance and showcase. In view of such divergent notings by the registry, it shall be explained the circumstances in which such divergent notings have been given. That is dated 21/7/2011 and 31/10/2023 through the Registrar Judicial. Para. The allotted Standing Council seeks liberty to take notice afresh by registered post with AD. Prayer is allowed. Let notice be issued to the opposite party by registered post with AD. Requisites for which shall be filed within 3 weeks. List after SR. This is in 46. This is in 46. 45 also same order. Yes, next 47. Right. Yes, 47. So Das. Now you cannot go by the noting also.
Well,
because after it is sufficient also they are giving a noting that not filed.
well.
Office note put up by the registry dated 31/10/2023 indicates that requisites for issuance of notice in question of limitation and admission to the sole opposite party by registered post with AD not filed. It will Mr. Sangram Das Standing Council for the petition. Opposite party blank. The allotted Standing Council prays for submits that due to inadvertence the requisites could not be filed and prays for further time. Prayer is allowed. Let requisites be filed for issuance of notice by registered post with AD to the opposite party in the present correct address within 3 weeks. You inform him.
Well,
Yes.
40
List after yes, sir.
48, my lord, there is a noting of miscase number 21 of 11.
Yes.
That is, my lord, extension of time for removing the defect. Because
Yes.
earlier there was, my lord, direction for perimeter direction for removing the defect. That was
Yes.
not done, and extension of time was sought for. Subsequently, my lord, miscase number 49 of 11.
Yes.
That is for condonation of delay has been filed by the petitioner state, my lord. That is
So
pending.
notice has to go.
No, notice has to go.
Go
And
in
your lordship may
49.
my lord. 49 of 20.
This case 49 of 2011.
Well.
This is item?
And this is 48, my lord.
48.
My lord.
देखो record रे कौन करिया. But anyway, it is there. I have seen them. आपन record देखो तो क्या कौन नहीं तो देखो नहीं.
Lordship may also dispose of
the miscase has been filed for seeking condonation of delay in filing the petition hard learned additional standing counsel. Appearance देखिए Mr. S.S. Mahapatra counsel. Issue notice. Issue notice to the sole opposite party by registered post with AD. Requisites be filed within 3 weeks. List after SR. Yes.
Next, that IA number, miscase number 21 of 11 may be disposed of because that was filed.
The next, Purpur लिखी थी तो miscase 21 of 2011.
Extending the time.
The miscase has been filed for filing of the for taking steps in filing petition for condonation of delay. For the reason stated in the petition and after hearing the learned additional standing counsel, the delay in filing the petition for condonation of delay is condoned. The miscase is disposed of. Then 49. Yes. Yes, next please. Yes,
49. 49, well, there is IA miscase for condonation of delay, notice to go.
Miscase 18 of 2011.
60, my lord.
No, this is CRLLP 64.
64, my lord.
So there is a delay. There is a petition for extension of time.
Hello?
The same as 63.
My lord.
So your file may not be containing that miscase.
My lord.
Or it has been earlier disposed of.
No. That is, my lord, only 60 of 2000.
No earlier order. So same order as in 63. The first miscase is 18 of 2011. No, it's a mistake, or I don't know. I don't understand who has filed this. You see, the earlier miscase was filed in 2007.
Well,
then what is the occasion of filing miscase 18 of 2011?
18 here in this case is
CRLLP 64 of 2007. Item 49.
There was, my lord, perimeter order. Lordship kindly have a glance. 18 is for extension of the time for filing the IA.
In fact, I have followed that.
Madam.
But please mark, 18 is filed in the year 2011.
11.
And when the petition for condonation of delay was filed, please mark the year.
60 of CA7.
So 4 years after, what is the necessity? It can be other way around.
Other defects.
I don't know. I don't
Maybe
understand.
With regard to other defects, my lord. No, that is for filing condemnation of delay petition. There was no necessity. It has been without any necessity that has been filed. 1311, there was a direction. That is with regard to, my lord, maybe with regard to other defects.
31 and 2011.
My lord. Maybe.
This case 18 of 2011. The Learned Counsel for the petitioner submits that the order dated 13/1/2010 that order is again a mistake. That order is 13 January 2011.
My lord, 11. By that time, the application for condemnation of delay was there. My lord. But
the defect as pointed by the SR is removed.
There is no noting in our file.
Our record shows the defect was removed on 13/1/2011.
11. But on the day itself, it has been removed. But subsequently, there was no necessity of filing the IA. That has been filed, my lord, on 21st January.
MC 18 of 2011. Apparent terms, SS Mahapatra ASC. The IA has been, the miscase has been filed for extension of time to remove the defects as pointed by the SR.
Mistake that has been
office note. Dated 21/2011 indicates that फाइल टा देखिए ऑन डेट ठीक कोडा डेट को नोट सीट देखिए नोट सीट रे देखिए दे पावना मते दियो एटा 21 ना 31 ना 24/3 कोटा सेटा 21 रे ठीक अछि त बसन ऑफिस नोट डेटेड 21/2011 indicates that neat typed copy of the judgment has been filed, no other defects. Hence, defect as per SR removed. Within quote kar diya. Within quotation, removed. Quote. In view of the above, Pasapara, in view of the above, the learned additional standing counsel doesn't want to press the miscase. Accordingly, the same is disposed of. Then miscase 60 of 2007. The miscase has been filed for condemnation of delay in filing the petition. Hard learned additional standing counsel for the petitioner issue notice. Requisites for issuance of notice by registered post with AD. Be filed within 3 weeks. List after service return.
Item 50, my lord, that is same to item 48. There is IA subsequent IA, my lord, for extending the time of removing the defect, and the miscase for condemnation of delay has been filed subsequently. This is IA number.
IA number 19 of 2011.
My lord.
Same appearance,
And the notice may be issued on 64, miscase number 64 of 2011.
The IA has been filed, but this is right 50. Miscase 19 of 2011. Yes. The IA has been filed for extension of time to comply with the order dated 31/1/2011, by which it was directed that the defects as per the stamp report be removed within 7 days. What is the defect also, it is not indicated. As per the stamp report, petition, the stamp report steps for limitation not taken. It is submitted by the learned ASC that already the miscase for condemnation of delay has been filed.
Miscase number 64.
64 of 2011 has been filed. Accordingly, the present miscase stands disposed of. Then 64. The miscase has been filed for condemnation of delay in filing the petition. Hard learned additional standing counsel issue notice. Let notice be issued to the opposite party by registered post with AD. Requisites for which shall be filed within 3 weeks. List after SR. Yes.
51. 51, my lord, there is non-payment of non-filing of the receipt with regard to payment of cost towards removal, my lord, condemnation of delay.
Yes.
Of 200 rupees. My lord, our file was missing. For that, I could not trace the receipt whether it has been filed or not. Again, my lord, we will file. Allow 1 week time to file the pay the cost and file the receipt.
Office note. This is item 51, Mr. Additional Standing Counsel for the state. The Lord Additional Standing Counsel submits that it may be accommodated to verify if the cost of rupees 200 has been deposited as directed by order dated the cost of rupees 200 to verify whether the cost of rupees whether the amount of rupees 200 has been paid to the learned counsel for the opposite parties.
If not paid, we'll pay again, my lord. We'll file the receipt.
It is submitted that since the case brief has been misplaced, the state may be permitted to pay the amount to the learned counsel appearing for the opposite party, if not already paid. Prayer is allowed. Further 3 weeks time granted to do the needful.
Well, obliged.
Yes.
52.
My lord, in item 52, the Hon'Ble Court directed to petitioner for filing 2 installment, rupees 30,000, 50,000 each, my lord. 1 installment is paid, but 1 installment not paid by the second installment not paid by the petitioner, my lord. And I have not contacted this, my lord, petitioner 2 weeks time require my for contact.
It is coming after 12 years.
My lord?
Coming after 12 years.
Yeah.
Now to instruction be ani paribani. Amar kebe miss IE kebe file kartile. Ko IE ta kahile? Extension of time,
my lord, 20 of 2011.
20 na 319. Apar second installment kouchandi to?
Aga.
20 no.
Na 20 order hitila 20 by 2011.
Sir, which miscase you are pressing? Na apana Mr. Boral ko mode re achanti?
My lord.
But upon Mr. Boral ko mode rahibe, you will think that the court doesn't understand anything. 3 upon ko miscase re prayer karchanti extension of time pai. Upon 20 kouchanti. Mu kouchi 319.
Right.
ନାଇଁ ପାଉନାହାନ୍ତି Copy nahi. Dekhon. Hey, because we have lot of time. Please don't worry about because yes.
Copy টা নাই।
Copy টা দিয়ে দিন। Flag C ଦେଖନ୍ତୁ
ମାଇଲା ମାଇଲା
अरे मिसकेस नंबर ठीक अच्छी तो मिसकेस 319 of 2011 the learned counsel for the Mr. B.K. Padhi for the petitioner the opposite party किए अछंती एटा प्राइवेट पार्टी
ରହିଲା।
ओके I miscase 319 of 2011, the learned counsel for the petitioner submits that the miscase has been filed for extension of time for payment of the second installment of rupees 15,000 as directed by the order dated 3/1/2011. 3/1 or 13/1/13/11.
3/1/11
3/1.
ମାଇଲା
But my brief looks like 3. 1 ଟା ତାପରେ 11 ଉପରେ ରହିଛି ଆଜ୍ଞା।
ମାଇଲା ଅଧେ ରହିଯାଇଛି ଅର୍ଡରଟା।
not 3. 13/1/2011. It is further submitted that since the matter is old one, it is further submitted by the learned counsel for the petitioner that he may be accommodated to obtain up-to-date instructions. How much time? ଆପଣ ସେଟା ଏପର୍ଯ୍ୟନ୍ତ ଡିପୋଜିଟ୍ କଲେଣି ନା ନାଇଁ କରିନାହାନ୍ତି ସେମିତି ମିସକେସ୍ ଫାଇଲ୍ କରିକି ତାପରେ ରହିଗଲେ
କରିନାହାନ୍ତି ମାଇଲା ତେଣୁ 2 weeks time
to up-to-date instruction as prayer is allowed 3 weeks time granted to do the needful.
My lord, I am appearing on behalf of Mr. P.K. Padhi.
Mr. P.K. Padhi on behalf of P.K. Padhi.
Obliged.
Yes.
53.
May I please your lordship?
After 3 weeks कर दियो 3 weeks time granted से जब आसुची नले 3 weeks पर डेट कर दियो. Yes.
May I please your lordship?
Just a second.
Madam.
28.
Yes. Yes, Mr. Ponda.
My lord, I have filed a miscase.
Yes.
22 number 22 of 2011 for condemnation of delay, your lordship. Your lordship, there is a 113 days delay to file this.
The other side has appeared. No one is appearing. What can be done, sir?
Yes. One Tukuna Mishra is appearing, your lordship, for the opposite party.
One Tukuna Mishra, no?
My
Mr. Tukuna Mishra.
Mr.
Your learned brother.
Sorry, my lord. He has appeared.
Madam is sitting. Madam, you are appearing on behalf of Tukuna Mishra. Are you appearing for Mr. Tukuna Mishra? Okay. Fine. So Nilakanta Panda for the petitioner, Mr. Here you are appearing, Mr. Standing Counsel, you are appearing. Mr. S.S. Mahapatra AC for the OP number 1. State.
I am up.
Mr. OP 2 and 3.
My lord.
None. The learned counsel for the petitioner IA 319 of 2011. This is IA 31. I'm sorry. This is I miscase 22 of 2011.
My lord.
The IA has been filed for delay, condonation of delay. The learned counsel for the petitioner shall serve a copy of the petition on the learned counsel appearing for the opposite party. How much time, sir? Within 7 working days. List on. Yes. 5/12. But I want to serve cordial, even if you have served earlier, so that yes.
54,
My lord, in this case.
Not filed.
My lord.
Not yet filed, or you have no instruction?
My lord.
Limited postal liquid is not filed.
Notice was issued on 24/6/11.
Yes.
But thereafter, let me verify, my lord. If it has become.
Miss M.S.S. Jenna for the petitioner. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction. If you are seeking, then you file the requisites also.
Yes, my lord.
Yes.
Obliged.
As prayed for. How much time?
My lord, a week time will serve.
3 weeks per date kar diyo.
29.
29/11. List on
Obliged.
29/11. Yes.
55,
Petitioner none to grant another opportunity to the none appears for the petitioner when the matter is called to grant another opportunity. List on 6/12/2023. Defects as pointed by the SR be removed in the meantime. Next, please. Yes.
56,
Petitioner none. Same order as 55. Defects be removed. Date kebe? 6/12. Okay. 57.
57,
My lord, 57 against the order of acquittal. This has been filed in
Say,
2000.
Typographical error ଅଛି.
Typographical error.
Error in the miscase.
Again, my lord, I don't think any purpose will be solved because acquittal is in the year 2010.
So grossly barred by limitation now.
Your lords may pass.
Problem is that this is not in order. Miss S. Jenna for the petitioner. CRL REV /95/2011 along with miscase 1, 2, 3 of 2011. The petition has been filed. The revision petition has been filed with a prayer for setting aside the order dated 6/7/2010 passed by the learned so and so and so. Dekhi lekhi so that bhul hoban. Though the delay condonation petition was filed on 2/2/20 filed on 2nd February 2011. Since there was a typographical error, it could not be taken up. In the meanwhile, 12 years have passed. Considering the nature of prayer made in the writ petition, and the facts and circumstances of the case, it is fairly submitted by the learned counsel for the petitioner that after a lapse of 12 years, the petition would not survive for adjudication before this court. Accordingly, the petition is disposed of.
Obliged.
Yes.
58 on behalf of Miss Mahapatra.
Yes.
The matter may kindly be adjourned.
Miss S. Jenna on behalf of Miss T. Mahapatra for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. As prayed for on behalf of the learned counsel for the petitioner. List on 7/12.
Obliged.
$59,
Yes. Petitioner none. None appears for the petitioner when the matter is called to grant further opportunity. List on
1/12.
1/12
60.
Wherever state is there, mention the name of the state council. Here you are not there. Yes, 60.
May I please, sir? Madam, on behalf of Devaskan Das, sir, may can be adjourned.
Your name, sir?
Sujit Satpathy.
59 defects be removed in the meantime. Last line add करती हूँ. 60 Mr. Sujit Satpathy on behalf of Devasnana Das for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the opposite party. The learned counsel for the petitioner seeks accommodation as prayed for. List on 30/11/2023. Defects as pointed by the SR be removed in the meantime. Yes.
61.
Yes. Yes, please.
Lordship, 2 weeks time.
Your name, madam?
Pragyasmita Das.
Pragyasmita
Das.
Das on behalf of Mr. Manas, Pragyasmita Das on behalf of Manas Chand for the petitioner, Mr. S.S. Mahapatra, additional standing counsel for the state. The order dated 8/1/2013 in Miss Case number 850 of 2012 records the following. Para. The learned counsel for the petitioner seeks further accommodation. As prayed for, list on 30/11/2023. The learned counsel for the petitioner shall produce the certificate indicating surrender of the petitioner. The registry shall also obtain a report from the court in session of the matter. Yes.
62.
Yes, please.
There's a miscase filed for a delay of 36 days in processing the present revision numbers. IA number.
Why SR has not been done?
I believe
36 days delay.
Notice, yes. Maybe condone minutes.
Condone? No, notice has to go. Sir, it's a substantive right.
My lords, notice was issued on the question of limitation. The requisites were filed on 23 July 2000.
And stay after ACR resurfacing, the 10 years it will not be there. You obtain instruction.
Notice is gone, my lords. The requisites have been filed.
Yes, sir. After that, the stay was also granted.
Gotcha.
But are you sure that the stay order is still operating? After the Supreme Court order, Supreme Court has twice clarified.
Again, I'll have to find out.
Yes. Your name, sir?
Anshuman Rai.
So Anshuman Rai.
On behalf of Shri DP Dal, senior.
Senior counsel, you can't represent, sir. You can engage the senior counsel.
Again.
Who is the advocate on record?
It was
now SK Das.
Milot.
SK Das achanti chamber re apanko.
I'll have to find out, Milot.
This is item 62.
So on behalf of SK Das, Milot, may kindly mention.
Sir Anshuman
Rai.
Mr. Anshuman Rai on behalf of SK Das for the petitioner.
Instructions for
notices on limitation. MC 815 of 2013. Notices were issued by order dated 22/7/2013. And interim stay of the further proceeding in 1cc case number 568 of 2012. Pending in the Court of Learned Special Judicial Magistrate Balasur was granted. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction. Registry shall also obtain the up-to-date instructions regarding pendency, regarding the status of the case, present status of the case from the learned court in season of the matter. List on
4/12.
Yes, next.
63.
My lord.
Yes.
63, my lord. The petitioner is the railways, my lord. Mr. Ponda is appearing on behalf of petitioner as Central Government Council.
Yes.
May I pray
that's nice.
Adjournment on behalf of Mr. Ponda. He is in problem, my lord.
I'm appearing for the opposite party.
Defects you have not removed.
I have no instruction regarding the brief, my lord.
Mr. Kabiraj Pradhan on behalf of S. Pondas, CGC. Mr. Rai, Anshuman Rai on behalf of B.S. Dasparida. For opposite parties.
I have my power is there in it.
You have power.
Yeah.
Mr. Rai for opposite parties 2, 3, 5 and 6. Learned counsel for the petitioner. A prayer for adjournment. A prayer for adjournment is made by on behalf of the learned counsel for the petitioner. The learned proxy counsel doesn't have instruction whether the defects have been removed in terms of the earlier order. As prayed for, list on 5/12/2023. Defects as pointed by the SR shall be removed if not removed in the meantime. Yes.
I'm grateful, man.
Yes. You inform Mr. Ponda, Mr. Pradhan.
My lord, my lord.
Yes.
64.
Mr. Santi. Mr. Santi Prasad Mohanty for the petitioner. Mr. Patel, anyone? Opposite party dash likhi debe. Opposite party none. The learned counsel for the petitioner seeks accommodation due to personal difficulty as prayed for, list on 13/12/2023. Yes, next please.
65.
Petitioner none, opposite party none. None appears for the parties when the matter is called. To grant further opportunity, list on 6/12/2023. Yes, next.
66.
Yes, 66.
This is my lord's leave to appeal
Yes.
against the judgment dated 27/10/2006.
Yes.
This case was filed under 332, 427, 307 IPC. The learned magistrate has held discarded basically PW7's testimony completely. He says the victim.
So, in fact, the delay has been condoned in absence of the other side. They are not appearing. So, you take admission notice again. And there's no point in keeping after 16 years. Or if you can say that there is nothing, so we can discuss and dispose it off.
If my lords will kindly have a look at PW7's deposition, I think that's the only thing that is material. When is the notice?
You take notice. By Mr. Devasis Naik, additional government advocate for the state. This is item 66.
66.
Opposite party, none. By order dated 2/3/2009, Miss Case number 56 of 2007, seeking condonation of delay was allowed. Though notice was issued in the Miss Case, seeking condonation of delay, and it was sufficient. No one has appeared on behalf of, no learned counsel has appeared on behalf of the opposite parties 1 and 2. issue notice on admission to the opposite party number 1 and 2 by registered post with AD. Requisites for issuance of notice in the present correct address be filed within 3 weeks. List after SR.
67.
67, my lords, can be disposed of. The only material witness, I mean, there is no evidence that was there produced. That evidence was not there. Cross-examination is very clear in what he's saying. So the evidence that was seized is not there in court for him to identify.
Just stick to the microphone. Or just
67.
67,
my lords, there are two material witnesses,
Yes.
PWs 2 and 3. PW3 is supposed to be the expert witness. This is a matter under Railway Property Unlawful Possession Act.
Yes.
The presumption is for the person who has been caught with the property to prove that how he came into possession of the property.
But that property has been proved.
That property, there was no mark. That is the finding of not in court at the time for identification.
It has not even produced or marked as
It was not
exhibit.
produced.
I mean the material object, MO.
Oh my lord, there is no. I'll just read out the deposition.
Mr. Devasis Naik, additional government advocate for the state. But here, APP Khurda. So that is how the state is there. Because in those matters, railway is appearing separately.
He says the articles
by order dated 10/8/2007, notices are issued on the question of admission. And LCR was called for by order dated 4/12/2007. There are three persons accused. Though notices as per notice, as per the office note dated 26/11/2007, notices have been sufficient on the opposite parties. Hard learned counsel for the learned AGA for the state. It is submitted by the learned AGA that the judgment and order dated so and so, passed by so and so, is liable to be set aside in view of the perverse finding and material irregularity. Para. Yes. After going through the judgment rendered by the learned JMFC, Khurda. Yes, please refer to the paragraph you are referring
this is
to.
the judgment.
Yes, paragraph.
This is para 7 and 8.
Yes.
I'll place.
Yes.
As against the accused Nebulal Gupta, PW2 has deposed that one Dhaneswar Mohanto had to lead them to the scrap godown, and he was disposing the theft of railway properties in the scrap godown of the accused Narayan and Vijay. And seeing them, the accused Nebulal tried to flee away from the spot, but he was apprehended. It is mentioned here that PW2 in cross-examination has specifically deposed that he has not made Dhaneswar Mohanto as an accused in this case, though he had confessed before them that he had disposed of the railway properties of accused Vijay and Narayan. PW2 has further deposed that on search, they recovered 18 numbers of iron clips, 2 numbers of brake blocks, 2 numbers of lashing chains, 1 fist plate, 1 R-ring plate, 15 numbers of steel keys, and 4 numbers of fist plate bolts, and 35 kgs of broken CST 9 plate belonging to Indian Railways, and the said properties are not available in the market. PW2 has further deposed that the accused Dhaneswar identified the scrap godown of accused persons, namely Narayan and Vijay, but I have already discussed above that the said Dhaneswar has not been implicated in the present case. Though PW2 has seized the aforesaid railway properties under seizure list, but he has admitted that he has not signed on the said seizure list. But PW3 has deposed in cross-examination that the articles he had examined are not found in the court at the time of deposition. PW3 has also deposed that those articles were not found sealed at the time of their examination. There was no railway mark on those articles. Hence, the prosecution has failed to prove the articles seized from the accused Nebulal Gupta, which are railway properties. Hence, from the aforesaid discussion and from the totality of the evidence, I hold that the prosecution has miserably failed to prove its case beyond all reasonable doubt against the accused persons under Section 3A, railway property. Or
that's it. In the relevant paragraphs of the judgment where finding has been given regarding the culpability of the opposite party accused persons, the learned court has given a finding that as per the evidence of the PW7, who is the official witness, that is revenue supervisor, the plot number 252 was leased out in favor of one Brajalal Agarwala, who is not involved in the present case. Therefore, the basis of allegations against Narayana and Bijay, Narayana into bracket accused or opposite party kar debe, OP so and so, Narayana OP so and so, and Bijay OP so and so. On the basis that the plot number 252 belongs to them is unsustainable. The learned court has also relied on the depositions of the PW3, who is a expert witness, stating that the articles he had examined were not found in the court at the time of his deposition. That is, the material objects were not produced, were not available at the time of his deposition. Further, the learned court has given a categorical finding that the procedure for seizing the material objects were not followed, as the articles at the time of examination by him were not found in a sealed condition. In view of such evidence on record, the learned court came to a conclusion that the prosecution failed to prove that the articles seized from accused Nebulal Gupta into bracket OP kar debe are railway properties. In view of the above, this court does not find any illegality of the order. Illegality in the order dated so and so, so and so. Accordingly, the petition seeking leave is dismissed. Yes, next. Yes, next.
68. My lord, item 68 on the behalf of Mr. Naik and taken up next week, my lord.
Your name, sir?
Kittis Kumar Jena, my lord.
Mr. Kittis KK Jena. You are writing KK? KK Jena on behalf of PK Naik for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation to advance arguments as prayed for. List on 712. Yes. 69 next.
69.
I am for opposite party lordship.
138.
69.
अरे वन समझते कौन आजी कौन हिची कौन आजी
No, I am for opposite party lordship.
138 NI Act.
No, it is 144. He has challenged the order passed by the sub-divisional magistrate under section 140.
से कौन एकुटिया पारिबे आपण तो he is pitted against you in person कौन से आसु नाहंती.
In person, it is also not maintainable because he has not imputed the sub-divisional as party. The order which has been challenged, let a chance.
Petitioner none, Mr. Jajati Kishore Mohanty for the opposite party, 1 to 4, 1 to 41 or 4?
144 CRPC.
Are opposite party कौन आज
Opposite party 1, Your Lordship.
Opposite party 1 अपन sure?
Your Lordship.
Na court is wrong. वकालत नंबर कौन लिखचंद?
I may be wrong, Your Lordship. After 12
नहीं, you cannot be wrong. ଆପଣ ଆଜ୍ଞା 41 ଜଣଙ୍କ ପାଇଁ appear କରିଛନ୍ତି ଆପଣ 1 କହୁଛନ୍ତି 40 ଜଣଙ୍କୁ ଛାଡି ଦେଲେ
all opposite parties.
but you cannot be wrong of course. Jadati Kishore Mohanty for OPs 1 to 41. Yes. The petitioner was appearing person when the matter was last taken up by this court on 3/5/2011. Oh no, then also he did not appear. He kebe appear करना है? When the matter was taken up on 1/3/2011 and notices were issued by this court. Thereafter, on 28/3/2011, the petitioner did not appear. On 3/5/2011, the petitioner did not appear. Thereafter, the matter is listed today. Considering the nature of allegation made in the complaint of the he filed a complaint case.
He filed, my lord. He filed a 144 CRPC petition.
That is consider the nature of the allegations. That is a petition filed under the section 144 of the CRPC. This court is of the considered opinion that nothing would survive at present for adjudication. Accordingly, the matter, the petition is disposed of. Yes.
70,
my lord. It is arising out of 145 proceeding.
Yes. Nothing would survive, sir. 145 रे कौन survive करियो अबे?
नहीं, more possession reversing judgment.
Yes.
Magistrate declared my possession. Now,
this is always along with a civil proceeding.
Well,
without civil proceeding, there is no 144. I think you will vouch for that. You and
it is not like this.
Yes.
This land, disputed land, was settled with me as I am a land austee. My both homestead and agricultural land submerged in the project of Rengal Dam project.
Yes.
I am a land austee.
Yes, please.
I applied for a piece of land for my residential house. After due inquiry and following the procedure of law, this land was settled in my land.
No, status quo was granted. It is maintained till date.
Till date.
Then Mr. Parda, after 12 years of status quo,
sir, nothing survives in this case, my lord. 60 days generally would have civil proceeding for declaration ki kon karibe.
ये वर्तमान वो टाइटल टाकू चैलेंज करूछन्ते
I may be wrong also, but the question is that what happened in the parallel civil proceeding?
Civil proceeding, I don't have any.
Then what is the what purpose will be served? How it will benefit the person? A status quo they are not. You see, you have obtained a status quo order in your favor.
Right.
That is continuing since last 12 years.
Yes.
So what more is left?
Only
144 restraint order was refused.
No, 144.
145. 145 was refused.
You allowed to by the magistrate, reverse by
against you or
right, madam. My lord.
That you have got a status quo order in your favor. Status quo means status quo as far as possession is concerned. Then what more remains in this petition now today? That I was asking you.
Regarding that finding of
and obviously regarding right title interest about this court in this proceeding has also concern also.
No. Either of the party will.
Obviously, they cannot insist. And you see, they have tolerated the status quo order. I don't know for what purpose.
Yes.
So basically, nothing would survive. You take instruction. I have no problem in adjourning.
Yes, I am taking.
But after that status quo order in 2011 in the 145 proceeding, after 12 years, what this court will adjudicate?
I will take instruction whether
Yes, obviously, because there is no stay of any civil proceeding,
No.
any other proceeding as far as this revision is concerned.
No, my lord.
So far as my instruction is concerned, my lord, no civil suit has been filed either by us or by the petitioner, my lord. No civil case.
He is candidly saying that they have also not filed any civil suit.
They have not filed any.
So obviously, so that is how
Right.
the status quo order was not registered by them.
Yes.
Because after you got the status quo order, after your case was somewhat negated by the learned court below, the learned magistrate, thereafter you have got a status quo order and it is remaining since last 12 years. You obtain instruction. How much time, sir?
2 weeks. Or
sorry?
Or December, then 2 weeks. 2 weeks, I will take instruction. Okay.
No problem. The court is encouraged that you are appearing and at least advancing some point. So that is why I am saying that you take adjournment and again advance also some points. Mr. D.K. Sahu for the petitioner, Mr. Parida,
Yes.
on behalf of the opposite party, G.N. Parida. The learned counsel for the parties shall obtain up-to-date instructions in the matter for the fact that by order dated 30/5/2011, status quo as on that date in respect of the land in question was directed to be maintained by the parties. In fact, the order has faded. In the last 12 years,
Right.
that order has faded. I have the advantage of enlarging it, so I am able to read it. As spread for list on 29/11.
Obliged.
71.
Is this petitioner none, opposite party none? It's complaint case. (138). None appears for the petitioner, none appears for the opposite part, none appears for the appearing parties when the matter is called. The matter has never been listed or taken up. After notices were issued by this court by order dated এটা কোন ওভার রেটিং হয়ে যাইছি 12/4/2013 to grant other opportunity to the parties list on 18 he appear করুনাহান্তি, no one is appearing. 18 is a Saturday. On 20/11/2023. Yes. Order dated 12/4/2013. କେତେ କହୁଛନ୍ତି ଆପଣ? 12/4/2013. Yes.
72.
Item 72.
Yes.
Appearing for the opposite party. Counsel for the petitioner is not there.
Petitioner none, Mr. S.K. Joshi for the opposite party. None appears for the petitioner when the matter is called. He is not appearing since last so many days.
Let another opportunity be given.
None had appeared when the matter was last taken up on 9/12/2017.
My lord.
In the National Lok Adalat. To grant Further opportunity to the petitioner list on 7/12/2023. Yes, next.
73.
And for the petitioner, my lord.
Yes.
In this case, my lord, we need to some instruction, my lord.
Your name, sir?
J. Pradhan.
J. Pradhan for the petitioner, Mr. S.S. Mahapatra, Additional Standing Counsel for the State. And I counsel for the petitioner seeks accommodation to obtain up-to-date instructions as paid for list on 8/12/2023.
My lord, interim, there is a stay order, my lord.
Stay order, when it was the last order, when it was last taken up.
My lord.
Sir, that is 9 years. I am not going to extend after 9 years. I do not know what has happened after HNC resurfacing. Please appreciate that. So you keep quiet wherever there is an interim order. No further subsequent order is there. It is better you should remain silent. Because after Asian resurfacing, subsequently also clarified again by the Supreme Court, most of the stay orders are not being prevailing, further prevailing. And the matter would have, concluded also, most likely. You obtain up-to-date instruction. Yes, next.
74.
74, I seek for an adjournment.
Mr. S. Mahapatra for the petitioner, Mr. Standing Counsel for the opposite party, State, P.K. Praraj. Learned Counsel for the petitioner seeks accommodation to advance arguments as paid for. You are Mr. P. Mahapatra.
S. Mahapatra.
Mr. S. Mahapatra. S. Mahapatra, actually. Yes. As paid for list on 8/12.
Obviously.
Yes.
75.
This is against a confirming judgment.
Yes.
The original judgment conviction was to undergo RI for 1 year and to pay a fine of ₹1,000.
Yes.
Subsequently, it was confirmed by the census judge Keunjhar.
Yes.
For conviction under section 363(34) IPC.
Yes. So any modification of the sentence?
No modification. The same confirms as usually.
So can it be any period he has already undergone imprisonment or incarceration?
That is not within my knowledge. Must have gone, but in the initial days. But after conviction, they were in bail. After conviction also by the sessions judge, this court has allowed them bail. Maximum can be done there. First offender PO Act can be extended because the case is like this. The victim, alleged to have been of unsound mind, she has pelted stone to the bus of the petitioner. Petitioner number 1 is the owner of the bus. Petitioner number 2 is the conductor. She has pelted a stone by which the front glass broken, and thereafter it is alleged that she was taken to the house of the owner.
Probation of Offenders Act.
Nothing actually happened to her. And the family members, they have not also inquired where she has gone in the next day evening.
Whole problem is that you are not confining to the judgment. I don't understand this. If you have two confirming judgments, then you have to find out which part of the judgment is perverse, contrary to the evidence on record.
Yes.
So what is the point in this court or you deliberating on what happened?
There is a lot of contradiction so far deposition is concerned from the PWs. Lot of in material particulars there is so much discrepancy.
Who threw the stone? The unsound person with unsound mind, or who has thrown the stone?
That lady. Lady has thrown. She is the victim. She was kidnapped. It is alleged that she was kidnapped. Even if it is alleged that the boss has taken that lady, neither the family members nor the police also inquired where the lady gone. Absolutely improbable case.
Sir, absolutely improbable according to you.
Yeah.
But how the learned court has arrived at the probabilities, that you have to show.
The court.
Can I dictate an order that since Mr. R.N. Mishra said
No.
So then how could you please argue on merit? You please argue on merit.
I will argue on merit.
But if the conviction is upheld, but the sentence is modified, will you be satisfied?
Modified to what extent? It is only 1 year.
Maximum is 7 years.
Maximum is 7 years.
So what is the punishment for you have no instruction how much period they have stayed in jail custody?
Then I will
But
take,
all through they were in bail.
I will take instruction in the meantime because it was a
And in these kind of cases, if Probation of Offenders Act is applicable.
Yeah.
Yes, Mr. Standing Counsel.
It can be applicable because it's first offender. And no serious crime was conducted.
Yes, my lord. Serious crime. Testimony of my lord. PW2 was there, my lord. She was taken by in the bus towards Champua. She had caused damage to the said bus. PW2, my lord, the evidence of PW2, 5, 6, 8, 10, 11, and 12, my lord.
What happened? What Mr. Misra is saying that what happened to that old woman? What they have done? Somebody throwing a stone to the front glass.
Yes, madam.
After that, they pick up that person.
Yes, ma'am.
Carry the person in the bus. So bus must be other passengers who were there. So then what happened to her?
Nothing by the prosecution. No physical injury was caused, nothing but.
Sir, that is not the point, sir. Physical injury is an essential ingredient of 363.
No, not like no.
What is the point, sir? Please
Nothing
argue on
was
merit.
nothing was attributed to her.
Please argue on merit. What best can be done, and always have your interest of the client in mind.
My lord, there is para 13 of the trial court judgment. There is no evidence on record as to what happened to the victim lady after she was taken out from the spot by the accused person on the death.
No, her statement has been recorded, or some co-passenger statement has been recorded.
Only one co-passenger's statement was recorded. He is PW 13. Who has?
So then 1 to 13, there's a lot of so many persons have deposed against you.
No. Everybody has deposed.
Then they have
not seen it. Most of the witnesses have had only. They have not seen.
No.
It is the deposition very much.
There is also evidence on record to the effect that while the said victim was detained, she managed to flee away.
She fled away.
But that means offense doesn't go, man. 363 will be there.
But how to prove in a beyond all reasonable doubt that she was taken away, kept somewhere in confinement? Traveling in bus is confinement.
Well, that I don't have a copy of the depositions.
Since we have time and
a copy of the depositions are not there. Actually, that has to be elaborated. Actually, I will move fully with it.
How the matter?
Perhaps the confinement was also not completed. Suppose someone is carrying somebody is traveling in a bus. After she or he alights, he will be taken to confinement. But she alights and runs away.
Well, for sometimes she was in illegal confinement. For sometimes, my lord, that means offense. Since she's a lunatic lady, my lord, she fled away or something. But since she was taken in the bus forcibly, that 363 attracts.
Where it is defined, sir. Here they have been held guilty of
363.
363.
PW10 is an eyewitness to the occurrence as per the testimony of PW5. PW5, my lord, it appears from the evidence of PW10 that Mahakali bus took away the mother of the informant. Staffs of the bus chased the mother.
I don't think actually, maybe at times we find it difficult to spend time. But 361 will not be there.
363.
363 is punishment for kidnapping.
Yes.
So the substantive offense is 361.
61. Yes.
Kindly see 361.
Whoever takes or entices any minor, that will not, or any person of unsound mind.
That is satisfied. Then read slowly.
Out of keeping of the unlawful guardian of such minor or person unsound mind.
So
without consent.
out of keeping of such unlawful of the guardian.
Lawful guardian.
So the guardian has to be examined.
In this case, my lord.
Yes, obviously.
I have to see, my lord. So, UW8 is the son and victim of the son of the victim. UW6, my lord, stated that the old woman was tired in the bus and he left the spot.
So that I was asking him. PW6.
PW6 has seen.
6 is a co-passenger.
My lord,
No, he's an outsider of the village.
he left the spot. He has seen the, my lord. So
He was not a co-passenger. Co-passenger was only PW13. Six told tired the lady in the bus, but no other witnesses told about that. Not a single witness.
ଆପଣ ତାକୁ demolish କରିଛନ୍ତି କି?
No, not in their
ତାହେଲେ କାହିଁକି
statement.
sir?
ମୁଁ ଯାହା କହୁଛି ଆପଣ ତାକୁ ପାଳି ଦଉଛନ୍ତି
ଆପଣ ତାକୁ demolish ଯଦି କରିଛନ୍ତି କୁହନ୍ତୁ that witness was demolished by the cross examination.
No, this fact, the lady was tired in the bus is not supported by anybody's evidence. All 14 witnesses, nobody
Sir,
has
he is
told.
saying specifically PW6, you are saying, not anybody's evidence. Have you demolished PW6 in cross examination?
Yes.
Then see that, then show that.
Yes.
But para 6 lords may see, PW5 appears to be an eyewitness to the occurrence. He states before the court that on such and such day, the mother of the infant who has partially mental affected person threw a stone to the front glass of the Mahakali bus at Subhadradipur near the house of the Hari Mahanta. As a result, the front glass of the said was damaged. After this incident, the bus stopped. The owner of the said bus said the old woman caught hold of her and brought her inside the bus. PW5 further deposed that he requested the bus owner to leave that old lady since he was mentally ill. He also requested the driver of the said bus for the same, but the bus left the spot, taking the said woman, old lady. Before said bus left the spot, the owner of the said vehicle shouting to take the lady and to push her somewhere near the river or live somewhere in the forest. Para 2 of the evidence of PW transferred that the spot of the occurrence is in front of the, that corroborates the spot of occurrence. One Kesava have seen the occurrence. One Kesava Munda, Pavitra Marana, and Satrugana Mahantas have seen the occurrence. It appears from the evidence of PW5 that his house is distance of PW. Nothing has been brought out to from the mouth of this PWR by the defense to discredit his version to the effect that in his presence, the owner and the staffs of the bus concerned took the victim lady in the said box forcibly towards Champua. PW5 testimony has not been demolished.
The owner was traveling in the bus.
As it seems.
PW13 categorical told the owner was not inside the bus.
You see that is a double-edged weapon, Mr. Misra. Then the lady was carried to your home and you detained there. That is the allegation.
Well, out of 6 witnesses regarding.
Sir, you have to argue what is the best point in your favor.
The catching of the lady, PW6.
So the offense started there. But it was completed when you detained the lady inside your house.
Yeah. But that was not told by anybody.
That has been told. That is the sole case.
My lord, from the very beginning, PW10 lady entered to my house. Mo gharu ko asila, mo gharu drag kariki nele. It is not supported by any of the witnesses. Rather, on the other hand,
that is not the case. You are reading something else.
That is the beginning of the case. That is the beginning of the story. How she was taken.
PW5 in front of the shop of Hari Mahanta, the boss picked up the lady. You
owner chased the lady.
You just
other witnesses
quietly read the cross-examination of PW5. If you can find anything, you submit that.
PW5.
And he's a natural witness to the occurrence because his house is located 200 meters from the shop of Hari Mahanta.
My lord, that man has also told actually the occurrence took place on 9/5. He has told categorically on 10/5 at about 10:30.
Sir, date you have to.
That may not be so material.
Sir, not material. Have you asked that question? Sir, you first you see the deposition. Have you asked that question to the person in the cross-examination?
Miller. I was working, Samiti member.
9/5, 10/5, you just.
No, I am not emphasizing.
Then, sir, we are wasting time. Please confine your argument to the merits.
His testimony should be supported with others' testimony.
Sir, that is not a requirement.
It is required. How?
Sir, you show me some provision where everyone in unison will sing one tune.
No, almost. Out of 5 witnesses.
One material witness is sufficient. Whether you have demolished PW5, you show that.
Prosecution was done by them.
Statement of PW5.
Thereafter, PW6, my lord. It appears from the evidence of PW6 that occurrence of this case took place on the upper bus stand of his village. His house situated near the upper bus stand of the village. Hearing halla, he rushed to the spot. He came to know that from the first that people that old woman was mentally affected person pelted a stone to the Malkali bus, thereby damaged his frontless. It further appears from the evidence that the old woman was tired in the bus and had left the spot. Nothing has been entrained from the mouth of the witnesses by defense, discrediting the version of PW6 that he had direct knowledge about cross-examination. The PW8 was informant son of the victim. The PW10 is the eyewitness to the occurrence.
ଆପଣ ବସ୍ ର ନାଁଟା ବି ସେମିତି ମା କାଳୀ ବୋଲି ଆପଣ ଏମିତି ଅସୁବିଧାରେ ପଡିଲେ ଆପଣ କାହିଁକି ଗୋଡଉଥିଲେ ତାଙ୍କୁ ଆପଣ ତ ଯାଇକି ଥାନାରେ ଏଫଆଇଆର ଦେଇଥାନ୍ତେ
ଠିକ ଅଛି ଆପଣଙ୍କର
ଦିସ୍ ଜଜମେଣ୍ଟ ୱିଲ୍ ବି ଅପିଲ୍ଡ ହାଜ୍ ଟୁ ବି ଅପିଲ୍ଡ କିଛି ତ ନାହିଁ ଆପଣ ଯାହା କହୁଛନ୍ତି କିଛି ନାହିଁ
I am saying
which witness you will rely or which witness favoring prosecution has been discredited ସେତେବେଳେ ମୁଁ ପଚାରୁଛି କୋଉ witness discredited
PW6
He has not been
PW10,
discredited. He has not been discredited.
PW5,
Nothing,
PW11, all have stated different stories.
Sir,
all have stated.
Sir, have you asked those questions, confronted the witness by putting cross-examination? Don't give a narrative here.
No, that is their
Sir, your
deposition.
duty, sir, your duty as a defense is that you confront the witness that whatever you are saying, you are contrary to
I know
PW5.
that. I am not
So
excluding.
please,
No,
sir,
my
sir,
lord.
sir,
This is their
sir,
statement.
see, I am not, you are not, I am not doing a trial here.
No,
that you are arguing.
I am not saying that.
So please stop there.
No, I am confiding.
Mr. Mishra, you must be conscious that we are now in a live 24/7 YouTube channel.
Yeah.
So whatever you are saying must conform to law.
My lord,
you do not ask any question to the person to discredit him. You develop a story that I have to record. That I have to record.
I am
that no
not
question has been
developing
asked.
anything. I am saying what is on record. I am from record. I am saying.
Sir, what is on record?
The
You are
honorable
not saying.
magistrate has come to a conclusion.
Where you have asked these questions to PW to discredit him. That your version is at variance with other eyewitness. Where is the question?
How they can ask PW5 when told?
Sir, don't ask me question.
PW4 was.
Sir, don't ask me how they can ask. That is your submission.
PW4.
Your submission is that statement of PWs 5 and 6 are contradictory to each other. Where is that question you have asked them? What is their answer?
How can once PW10 went out of the court and PW11 came?
Sir, you are not getting, sir. You are arguing against yourself. After PW5 deposes, PW6 comes. Your submission is that PW6 person is in contrast to PW5. Have you asked this to PW6?
It is not required.
Then
how it is required?
So it is not required. Mr. M.R. Mishra.
I am just placing one thing, my lord. So far in the material particulars of the case, that lady was taken. How she was taken? By after pelting the stone, what happened? In that, all are different story. All have stated different story. By in the deposition itself, they have told. PW6 told she was tired. PW10 told she entered in my house.
Mr. Mishra, the learned court has not relied on. If you wanted to rely on 7, 10, 11, 13, whatever. I'm not giving exact number.
The corroboration part
has not relied. The court, it is your duty to demolish PW6.
PW6 probably, to my knowledge, was demolished.
Can it be a probability, sir, after two confirming judgments?
That is demolished. PW6 regarding tired.
Where?
The cross-examination last part, question number 4 of the.
She was taken. What happened to her inside the bus is not being asked. The question asked to you is that the lady was picked up in the bus and put inside the bus.
Yeah.
Where you have discredited that?
No, that has not been discredited.
Then what remains?
That has not been. That has not been. But
because causing hurt will be different section also.
It is not question of causing hurt.
So then
my lord, I am giving emphasis to one thing. Prior to taking, how they have changed, who has changed, whether changed in front of the boss. Somebody told she came to my house.
These things you should have argued in trial. You have tried to adduce evidence.
Not
after two confirming judgments.
That's why
at High Court.
That's why I without going to the merit of the case, honestly, I have.
Mr. for the.
I have submitted for
Mr.
acquittal on PO.
No, that I appreciate. That I appreciate. But that if you want a serious, if you want to seriously argue the matter, it has to be on merit.
No,
not like this. What you are saying is bereft of records.
No, I have not.
Mr. R.N. Mishra for the petitioner, Mr. Standing Counsel for the state. The petition has been filed challenging the order dated 18/12/2010 passed by the London Sessions Judge Keunjhar. In Criminal Appeal number 60 of 2008. Confirming the judgment dated 19/5/2008 passed by the London SDJM Champua. In GR case number 83 of 1999. corresponding to Bari PS case number 17 of 1999. The appellants before this court, appellants number 1 and 2, have been held to be guilty of offences committed under
363-34.
Section 363/34 of IPC. And a sentence of
RI of 1 year to each.
And a sentence of rigorous imprisonment for 1 year has been imposed, and it is further as a further punishment, fine of rupees 1,000 was imposed on each. The fine has been stayed or you have deposited?
No, it has been stayed.
This court, while admitting the matter on 22nd February 2011, granted bail to the petitioners fine was stayed by which order, sir?
Fine was stayed by order dated 22nd February 2011 by Honorable Justice Ayman.
By the order dated, sir, I didn't ask you the name of the judge, because I myself a judge reading the order.
I am not saying that.
So please,
what is written,
get rid of these habits. Get rid of. You are telling a High Court judge that the earlier order was passed by a High Court judge.
22nd February 2011.
So stop there. I didn't ask you also. By the order dated, the relation of fine was stayed by this court by the order dated 22nd February 2011. Having gone through the judgments passed by the learned court in appeal, that is the judge dated 18/12/2010, as well as that of the court in the original side, SDJM Champua, considering the evidence on record, that is the statement of PW 6, regarding the accused persons catching hold of the old lady after she broke the glass of the bus, she being taken up in the bus and confined to the same, and ultimately being detained by the accused persons as has been held. Has to be believed. On perusal of here the LCR is there. Oh, it's easy. On perusal of the examination in chief as well as the cross-examination of the PWs 5 and 6 contained in the LCR, No discrepancy could be can be found as far as the statement regarding confining the victim to the bus is concerned. The learned counsel for the petitioner, yes, you are having that copy of this. Are Prevention of Corruption Act kon douchandi sir. Probation of Offenders Act diyantu.
You are.
The learned counsel for the petitioner submits that the petition, all the accused persons had no history of any allegations against them as far as criminal allegations are concerned. It is further submitted that the petitioners acted in a spur of the moment when their property was damaged by the lady by throwing stone. And in a immediate reaction to the said loss, the petitioners acted without any intention. Yes. The learned standing counsel, in his submission, supported both the judgments passed by the learned trial court as well as the learned court in appeal. He refers to the statement of the witnesses.
PW eyewitness PW 5, 10 and 11 and 6.
5, 6, 10 and 11.
5, 6,
5,
10
6, 10 and 11 kar. Having heard the learned counsel for the petitioner
and 8
5,
out
6,
informant.
8, 10 and 11.
8.
10 and 11. और ऊपर भी से नंबर गुड़ा पके देबे ठीक है सार को दियंतु दीटा कॉपी अछि की लिख to submit that the finding of the learned trial court as well as the order confirming the judgment of the trial court cannot be faulted with. Having heard learned counsel for the petitioner and the learned standing counsel, in contrary opinion of this court, this court is not inclined. This court is not inclined to interfere with the order passed by the learned appellate court, dated so and so, passed by so and so, and the learned trial court, dated so and so, passed by so and so. However, considering the submissions of the learned counsel for the petitioner regarding order to be passed under the provisions of the Prohibition of Offenders Act, this court releases the petitioners. Co-section 4 on probation under the provisions of the Section 4 of the Prohibition of Offenders Act.
But the conviction is not for death. It is much less than that. 4.
At least you will be sure that I have assisted more than you have assisted me.
Definitely.
So then let me do that also. और लिख ले सेक्शन अंडर सेक्शन 4 मतलब आपण का डाकुना जदी निजे आ का डाकुना जदी प्रॉब्लम होची कोन लिखले मु पढिले मु बुझी परनी provision contained in section 4 of the PO Act, 1958. This court, having regard to the circumstances of the case, including the nature of the offense, the character of the offender, especially their past conduct, feels it expedient to release them on probation of good conduct. Notwithstanding anything contained in any other law for the time being in force, since the petitioner have been already released on bail by order dated
22nd February 2011.
ठीक है रोहन और लिख ले 22 February 2011. If I impose the same conditions of the bail, what is your submission on that?
And they will be released on again bail.
No.
They will
Condition of release on probation.
Yeah, with certain conditions.
With same conditions.
Oh, yes, your lordship, no problem.
कौन लिख ले? Well, 11. This court feels it appropriate to modify the sentence. Modify the sentence imposed by the learned trial court, confirmed by the learned appellate court, to the extent that both the appellants shall be released on the conditions. Both appellants who are already under bail granted by this court shall enter into a bond to appear and receive sentence when called upon during the period. And in the meantime, they shall keep peace and they shall be of good behavior. Yes, you just also see that. But I got type करते it I got type करी दियो or this shall stand discharged.
My lord.
This bond of 20,000 granting bail shall be discharged.
No, my lord, that will not be discharged.
Okay.
That is because conviction is confirmed. For that, my lord, that forfeited, my lord, in favor of the state.
Okay.
Only his conduct, as per the PO Act, my lord, he has to ensure the bond for file the furnish the bond with regard to ensuring her further conduct. Good behavior.
And that they will do.
But when the conviction is sustained, that fine and the security bond is given during bail, that will forfeit in favor of the state.
Okay. In view of the confirmation of the conviction, the fine amount shall be forfeited in favor of the state.
And he has to pay the fine.
After deposit of the same,
Only fine now.
prior to be released on
Fine as well as the
provisions of the PO Act.
whatever, my lord, he has cash security or something,
Yes,
my
yes.
lord, has given in
Yes.
during the bail.
That has to be
That has
Release,
Yes.
in cash.
release in the PO Act also fine can be ignored.
So that provision, sir, you are not assisting that way, sir. If you bring that to notice to the court of specific provision, it can be done. In fact, you did not seriously contest before now the order has been dictated.
They have
You never seriously contested before the court that this never happened.
They have done it in Kenjusar and Champa.
Whatever. That is how it. Yes, next. How come what is it? Rest of the matters up to 100, since it is already court time is over. Only the matters which have been mentioned that will be taken up mentioned for adjournment only. Others are not reached.
Item 87, I pray for adjournment.
87, it will be listed again. So don't worry. Whatever matters are not reached, since now it is already court time is 4:30 or 4:15. 4:30 is over. So I am not calling the list anymore. But the matters those matters that they were mentioned in the morning, only those orders will be passed. So you can be rest assured that no matter is called any further. Right. Yes. Start typing. 76. Yes. State Council from 77 to 100. You are there, Mr. Naik?
From 81 to 80 to 86, I am there. 87.
82?
84.
Go to the mention.
I'm there, my lord, from 81 to 87.
Mr. Standing Council is up to? Your matters are up to?
My lord, my matters are up to, my lord,
88 to 94.
88 to 90.
No, 77 is yours.
77, my lord, belongs to Mr. Kanungo.
Kanungo, okay. 77 is...
My lord, 74
so now we are, I'm sorry, we are in 75. No, 75
to 80.
75 is Mr. Standing Council.
Kanungo. I'm there, but see your lord.
75 is Standing Council along with Kanungo. Or Standing Council, let it be there. Then 76 to
80.
80 is
Mr. Kanungo.
Yes.
81 to 87, my friend Mr. Naik.
81 to 87, Mr. Naik.
Yes, ma'am. 88 to 90 for myself.
Just a second. 81 to 87.
Well.
Then 88 to
90 for myself.
Yes.
95 to 100, my friend Mr. Map.
Yes. Okay. Thank you.
Thank you. Obliged.
Now, next is item 76. Mr. Amitabh Tripathi for the petitioner. Mr. Satyasundar Kanungo, additional government advocate for the state. The rest of the matters are all not called, not reached. Mr. Satyasundar Kanungo for the state. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 15/12/2023.
77.
Mr. S.S. Lenka on behalf of P.K. Rautrai for the petitioner. Mr. Satyasundar Kanungo, AGA for the state. Learned counsel for the petitioner seeks accommodation due to non-availability of the learned arguing counsel as prayed for list on 13/12/2023. Next.
78.
Same as 77.
79.
Mr. G.C. Sahoo, 79. Mr. G.C. Sahoo for the petitioner. Mr. S.S. Kanungo, AGA for the state. Learned counsel for the petitioner submits that he has instructions to appear in place of the earlier counsel, in place of the learned counsel who was appearing earlier. It is further submitted that the counsel who is appearing today shall file his wakalatnama and obtain up-to-date instruction. As prayed for, list on 14/12/2023.
Item 8.
880, not 880. Item 80. Mr. Rupam Misra on behalf of Mr. T. Misra for the petitioner. Mr. S.S. Kanungo, additional government advocate for the state opposite party. Learned counsel for the petitioner submits that the matter being a old one, he may be accommodated to obtain up-to-date instruction as prayed for, list on 13/12/2023.
Item 81.
Mr. H.K. Mohanta, M.O.H.A.N.T.A. 81, Mr. H.K. Mohanta for the petitioner. Mr. Debasis Naik, additional government advocate for the state opposite party. Learned counsel for the same as 81, same as 80, same order. Yes, next.
84.
84, Mr. P.K. Behra on behalf of S.N. Padhi for the petitioner. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for, list on 15/12/2023. Debasis Naik, additional government advocate.
92.
Mr. 92. Mr. Basudev Misra for the petitioner. Mr. Standing Counsel, T.K. Praharaj for the opposite party, state opposite party. Learned counsel for the petitioner submits that he may be accommodated to obtain up-to-date instructions, the matter being old one. As prayed for, list on 12/12/2023.
Item 99.
Mr. P.K. Malik, P.K. Malik on behalf of S.K. Das for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state opposite party. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions from the petitioner. As prayed for, list on 18/12/2023. Thank you. Thanks for your time.